based on those 14 patients' medical charts?
Yes, they are.
Now, you were discussing the differences between morphine and fentanyl. You recall that?
Yes.
And then I interrupted you with these other questions. Is it?
Now I want to ask you about, we've had numerous doctors testify that are internal medicine doctors. Can you tell me the differences between training between internal medicine doctors and anesthesiologists?
So, as an anesthesiologist, my focus was the care of patients in what's referred to as the perioperative period. So that would be people who are heading towards surgery. So it would require a knowledge of their medical conditions that could be in any number of things. You know, as an anesthesiologist, I touch on every kind of medical specialty and every kind of medical condition. Then after having made an assessment of their medical state, I would then move to plan an anesthetic that would require it to interact with their medical condition, surgery that was planned, and then I would care for them afterwards for a period of time in the recovery room, and that's kind of the broad concept of anesthesia. And in many of those areas, internists have some similar overlapping knowledge. What's different about anesthesiology is that not only is it a specialty of a cognitive nature, it's also a technical specialty. And so much of what I do as an anesthesiologist and also as an intensivist are things I do, frankly, with my hands. And so I'm required to do things, procedures, and to handle many of these kinds of medications constantly to draw up these particular kinds of say in this case, fentanyl and morphine into syringes, to inject them into patients on a constant, daily basis. So I have a lot of familiarity having seen the way that these drugs work in the body. And in that way, I think that my immediate knowledge and feedback, departs from my internal medicine colleagues who lack that kind of training and lack that kind of immediate practice. And having, again, done this for 27 years, I'm pretty comfortable, with syringes and needles and all of these medications, having injected all of them, into thousands and thousands of patients.
Which of the two specialties would be more familiar with that?
Oh, clearly anesthesiology and anesthesiology, clearly.
Okay.
Yeah.
And but internal medicine still work in the ICU?
Yeah, internists work in intensive care, and I actually, having been a fellowship director and also a member of a critical care team, I've trained internists who seek to become intensivists. So under my training, I have tried to give them some information that they lack, in their internal medicine training. Critical care has kind of specialties as well. There are subspecialties of the subspecialty, which is critical care medicine. So for me, for example, my subspecialty is care of patients who are undergoing cardiac or vascular or thoracic lung surgery. That's kind of a subspecialty. But I'm also considered to be a general intensivist. So I take my turn attending in a medical intensive care unit as well, and I'm comfortable doing that.
Is there a difference between pain control in the healthy versus pain control in people who are dying?
So there's an important difference in these two cases. So I think that probably all of us have had periods in our life where we've had pain. And pain, can be anything from, minor and annoying to crippling and disabling. And pain can be so severe that people wish for death, when they can't relieve the pain that they have. It's a spectrum. But in the case of where pain control is given to people who are very much alive and intend to remain so, there's a certain kind of pattern of prescribing that's intended to, again, reduce the painful symptoms, and so allows a person to otherwise function in their daily life. When we want pain not to be a barrier, we want it to be able to be something that we can accommodate so we can get on with it. Now, in the circumstance of when someone is dying, near the end of their life, it's a very different kind of project. So, first of all, I guess, the question is dying painful at all? And I think the answer is that yes, dying is presumably very painful. To watch it, having watched it many times, it looks that it can be quite painful for people.
Why?
Because, they, based upon simple things like simply what they say. People may say, I'm in pain, if they can, or they may, make sounds, of moaning, or in the way that their body moves, and just bringing to bear one's own empathy, the empathy of another person suffering, that we can recognize it, we're tooled for it, we can see it. We can see it even very slightly. It's our common humanity. And so I see it all the time. And, I register it. I'm affected by it. As my job as a physician, I don't want to leave it sitting. I want to seek to relieve the pain and suffering of the patients that I care for.
Can you tell the jury, explain to the jury what titration is, the concept of titration, and how it relates to anesthesiologists?
No problem, yeah. I'll tell you actually that when I began anesthesiology, I had trouble spelling that word. So I still have to think twice about it to make sure I'm spelling it correctly. So the idea of titration is to give a quantity sufficient, for the task. It means not to give too little. It means not to give too much. Now, it's difficult to know sometimes how much to give, and what are the consequences of giving too little and too much. In the case of when someone is dying, and if one imagines that that's the worst sort of pain, to be facing death, death would be the worst sort of pain. And so it's important, and I think comports with the common practice, to, in that circumstance, use a dose of medication, that would very likely be the sufficient quantity for the task. And so, in a sense, you're titrating, so that you're not giving a tiny quantity, and you're not giving an enormous quantity, but you're giving a goodly quantity that you believe, based upon your experience, that will be sufficient to immediately allay the problem of pain. I don't know. It might be helpful to draw this, or can I draw this, or?
Do I have permission to have the witness sit down so I can?
Yeah, I'm just curious on how you're going to do it.
Right here.
Did I just come down here?
Permission for the witness to step down, Judge?
I need to see what he's drawing. Okay, I can make it
Everyone
work.
see that?
Now on the far end.
You can see that back there? I'll move this stuff back.
Okay, before you start, why don't you explain to Ms. Mick what you're going to put up there?
Your Honor, may we have at least an offer of proof as to what is going to be drawn before something is on?
Okay, no. Let's do a sidebar.
Okay.
This is going to be a conversation. Ladies and gentlemen, get busy there. Sorry. Okay, doctor, you may, I'm sorry.
Sorry, I'm sorry.
I was used to your usual timing.
Doctor, you may sit down. Explain to us what you're talking about.
So, fair warning, I am not a very good drawer. And second of all, I am a teacher. I like to teach, but none of this is going to be on your test. So we're going to start with a very simple kind of drawing, and it goes like this. So this is a graph, okay? And on the bottom here, we're going to call this time, okay? So imagine that this is time 0, and we're just moving along this as time moves forward, okay? On this line, we're going to call this pain. Actually, it's going to be two things. It's going to be pain, first of all, okay? Also, public spelling was a little bit nerve-wracking too, but I'm pretty sure I'm not going to do spelling mistakes so far. So we're going to call this pain. And we're going to say, we're going to put like a mark here that we're going to call that pain, and we're going to draw a line that represents pain over time. And if you'll notice, the line is sort of going up. Okay, actually, I didn't quite draw it right, but the line should kind of be rising. Okay? So imagine that this is the moment where you're now interacting, where you discover this patient has pain. And this is like the pain line. Okay? Now, what I'm trying to do is I'm trying to give a drug that's going to manage the pain. Okay? And when I inject it, of course, before I inject it, this line is also going to now represent the dose.
Okay, stop. Use a different color for dose, please.
Sorry?
Do you have a different color marker for dose?
Okay.
You have a bunch of, I mean, you picked blue, and that's a Michigan thing, so
Try black for now.
don't try yellow. That'll just set this whale.
We're going to say this is now dose, which is in black, okay, dosage. So, at time 0, of course, before I've injected anything, there's no, in this case, fentanyl in the blood, so there'd be 0. Now, in my concept here, in order to get enough fentanyl in here, I've got to get over this pain line to make it work, okay? So if I give a small quantity, as an example, I inject it, and it rises, as I inject it, I leave it, and then eventually it falls. And so it may be something, say, like this, okay? Now you can see here that this was ineffective. So although I've given some pain medication, it wasn't enough. Okay, I didn't get near my pain line, and so the person is still suffering in pain. And so I have to, let's say, okay, I say, fine, all right, I got it. Let me try that again, okay? I'm going to give a second dose now, and maybe I'm going to not wait all the way, okay? I'm not going to wait till it goes to 0. There's still a little bit there. I'm going to try to give a second dose. So I give my second dose now. I'm not starting from 0 now. I'm starting from maybe here. I'm going to give another dose. It's going to look something kind of like, even if I give the same dose, it's going to get a little bit more because it's a little more, it kind of adds. But I'm still below the pain line, okay? And time continues to move forward, and the patient is still in pain and suffering. And so I try it again, and once again, I'm still below the pain line. So even though I redose these things and give more, I never get out to the pain line. And so it's very important that I pick the right quantity to begin with. So also imagine yourself in pain, and I'm saying, okay, hang on, it's going to take me about an hour to get under control of your pain. Like, that is not going to be acceptable to you. You want your pain control to be immediate, because the idea of being in pain and suffering for any length of time is intolerable. And so you want me, your doctor, to fix it right away. So I'm going to give a bigger dose, because what I'm trying to do, instead of this, I'm trying to do this. That's what I want to do. I want to get my dose to be big enough So the first time that I do it, I'm above the pain line. Now, what I didn't show you, didn't draw very well. So again, sorry, this line, imagine that this line is actually going up, okay? So the pain doesn't remain constant, of course. The pain is getting worse as time goes by. So it makes it extremely important, even if that first time I thought I got above the pain line, I still may be short, because the pain continues to worsen as a person maybe bears down on death. And so that's why you need to give this big dose, and that's like titration, okay? So I'm saying, how much is this going to hurt? Well, I think that the pain of dying is extreme, and so in response, I need to give a good and generous quantity, because I really want to get above the pain line, because of course here is death. And that's what I want to do.
And what's the difference between that and giving pain to someone who's healthy and alive, pain meds?
Well, so, there's some similarities here, okay, in that a person that has pain, maybe their pain line, actually, maybe I have the blue again. So we're talking now about pain that maybe is down over here, okay? So it's not the worst pain, if you can imagine, it's something less. And so in that case, I can use these lower dosages. It's acceptable, okay, to use this quantity for this kind of pain. But this kind of pain, the pain of dying, is more than this other pain. And so in this case, I need to give more. And in this case, I can get away with giving less.
What is anticipatory analgesia?
So the idea is, like in an operation, for example, a person is going to have a painful procedure. So the thing that I do, and some of you also may have had some experience like this, where you're anticipating that you're going to have pain. And so what we do is we give the pain control before the pain actually is in place. Because it turns out also that if you wait, once the pain is in place, it's harder to get on top of it, okay? So your doctor, for example, maybe you've had a surgical procedure and you've been prescribed some pain control and they tell you to go home. And then you are prescribed this pain control and you're instructed to take it every 8 hours or every 6 hours or every 4 hours. And if they're doing it right, they would say to you, maybe for the first day or two, take it regularly. So don't wait until you're in pain, because if you wait until the pain is bad, you need even more to get on top of it. It's difficult. So we anticipate it to be painful, and we kind of load you up with the pain control that you would need, so when you do have pain, it's much more manageable.
Okay. And what are the consequences if you don't get here during a palliative extubation?
Well, so
Okay,
then...
well, slow down. You need to tie that one in, because he's been talking differently.
Sure. What are the consequences of not reaching the level of pain while doing a palliative extubation?
Well, so the concern...
No, it's still not there.
Okay. What's the purpose of preemptive analgesia in palliative extubations?
Still don't have your foundation.
Preemptive analgesia, is that an accepted method of giving anesthesia or pain control?
Yes.
Okay. Is it something that's common in the practice of anesthesiologists?
Yes.
And critical care doctors?
Yes.
Is it utilized during palliative extubations?
Yes.
Well, explain to us how that applies in this scenario.
So the problem again is that there's this pain line, which is quite intense and high. And so, like I said to you before, if you were in pain, people naturally would want that period between being in pain and being relieved of pain to be as short as possible. And so I want to be able to make sure that time when we begin, when we start, and we say, now we're going to do this, we're going to now give you something for pain, people want that to happen as quickly as possible. And so they don't want to wait, and because if I'm doing this way, my risk, of course, is that I never get control of your pain, and then you die in pain, which is what we don't want to have happen.
Okay, you have to see that.
Put that away. Thank you.
Now I want to talk a little bit about the process of extubation. Is the process of a palliative extubation painful?
I mean, certainly it can be, yes.
Okay. And when doing preemptive analgesia in a palliative extubation setting, when is it done?
So what happens, so a patient, say, has respiratory difficulty. And so they're attached, through a tube, through a mechanical ventilator that is breathing, helping them breathe. Because without it, the act of breathing is difficult. And everyone knows what it feels like to be short of breath. It's an extremely uncomfortable and arguably terrifying experience in the extreme. And so it's very important to put in place, in this case, fentanyl, to blunt the kind of experience of being short of breath that can immediately occur when the ventilator is removed.
Okay. And what about the clinical picture of the patient? What happens once they're taken off of life support?
Well, I think that what can happen, and this it's a hard concept for people, because even the concept of life support, what does it mean? It can be a situation where a person's circulation is very damaged, their ability to circulate their blood, or their lungs are very, very weakened and ineffective, and so they need to be connected to machines with elevated levels of oxygen. Or their heart is very, very weakened, or their kidneys have failed. All of these things are common in my practice. And so there can be a place where a person is alive, but completely dependent upon machines and upon medicine. And so sometimes in conversations with families, when we're trying to kind of figure out where we are, I might say, well, this person, is alive, but can never leave this room. So as long as they are in this room with all this equipment, they're alive. But to get out of this room, they cannot. And so if they want to stay in this room connected to these machines, then I guess they can. But most people, when considering that, would say, well, I want to get out of this room. I want to get out of this hospital. I want to get out of this intensive care. I don't want to live like this. And so because they asked for it, these things are removed. And they're removed, and the idea of removing these things is to create a state of naturalness. And so now there is no block, to natural death, which would logically occur after these things are removed. Death is natural.
And how does that relate to comfort care?
So, comfort care, of course, is, when I talk to families, I have a common conversation. And families may say to me, well, actually, let me just back up. That, of course, as a doctor, my contract is with a patient, okay? And the patient is the boss of themselves, and they get to control what they want and what they don't want. Now, what's peculiar about intensive care is that the patient, I may never hear their voice. I may never see them standing upright. I never know them when they're well, and they can never talk to me because they're too sick. And so the entire relationship then dependent upon, what their loved ones, what their proxies are saying. So that's a very complicated position to be as a proxy, and I like to, somewhat cynically say sometimes the easiest pain to bear is someone else's. But for the proxy, it's very difficult because no one wants to think that it was them that, killed their relative or something horrifying like that. And so I instruct people, I say, the way this works is that your mouth opens and their words come out of your mouth. So we're here trying to engage together to try to figure out what this person in the bed would want, okay? So we've decided now that they think that this person in the bed does not want to be in this room, does not want to be on this equipment, does not want to live like this, and they want to be allowed, to have a natural death, that's what they choose. So in order to do that, of course, again, it requires the removal of these things, and families are frightened. They're frightened, and they say to me, well, what about pain? Like, is it, I'm worried that it will be painful. And so I reassure them, that we will do our very best to try to address the concerns of pain. And I've been in many situations like this where we're standing at the bedside and we've made this decision. And I'll say to them in advance now, if anyone here sees anything that looks like pain, say so, and we will give more. Okay? So, I don't like to have to go in and continue to give medications.
Why not?
I think it's distressing and alarming to people to see this. Trying to kind of create something that is, uninterrupted. That there's this kind of opportunity now to be with someone, to be with your loved one in as much as an uninterrupted fashion. So, one simple thing that I, for example, do is, most of you think of a hospital bed that has side rails, okay? They have these side rails, that are put up. So I go into a room when I'm going to do this and I put the side rails down, okay? And maybe their hands of the patients are underneath a blanket, and I take the hands, and I take them out from under the blanket, and I say to family, come close now if you want to. You can come right here. You can touch them. You can be with them. And I want to respect that, and I don't want to try to create anything that's too medical looking, where I have to inject stuff. And so, but I tell them, I ask them, and repeatedly sometimes, if anyone sees that this is painful, then let me know and we will treat that pain, because we don't want the person to be in pain when they die.
Okay, let me ask you, when creating a dose, well, before I go into that, we've heard a lot about vasopressors.
Yes.
Just briefly tell us what vasopressors are, because
Sure.
I don't want to spend too much time.
So, people, might know of something called hypertension or high blood pressure. It's possible that some of you have high blood pressure, and you're on a medication. But in the ICU, we tend to see not so much high blood pressure, we see low blood pressure. And low blood pressure is very dangerous if left unchecked. Now, low blood pressure can cause organ damage, and it can lead all the way to death. So, when people are sick, for a variety of reasons, their blood pressure tends to fall. And so a vasopressor is a drug that kind of pushes the blood pressure back up when injected. And that's why we give it in these sort of cases where circulation is broken or impaired and needs to be kind of propped up with these vasopressor medications, they're called.
And how does that affect the heart?
Well, so, the heart, if the blood pressure is low, it can be because the circulation itself is, well, let me give you an example, maybe a way of thinking about it. So picture a garden hose, okay? So you've got a garden hose, and you've turned the water on, and now you're standing with the garden hose, and water is coming out, okay? It's coming out under a certain force, okay? Now, if you put your finger over the end of the garden hose and partly block it, the intensity of the spray goes up, okay? So in the setting of either infection or other kinds of condition, it's as if you've taken your thumb off the end of the garden hose and now the water is sort of moving in a way that doesn't have a lot of force, okay? And so that can either be a consequence of kind of the garden hose itself, or it can be the tap. The tap is like the heart itself. So sometimes the heart needs to be, the tap has to be turned up, and sometimes the tap is turned down because the heart is not working and dysfunctional.
And how long does it take once you turn off a vasopressor for it to stop working?
So, vasopressors are by design, work very rapidly. And so their offset is equally rapid. So once you turn them off, in a matter of under 2 minutes maybe, the effects are gone.
And
Hold on a second. Hold on. Ladies and gentlemen, we're about an hour and a half. My desire is to go to 10 till 12 and give you guys an early lunch, but in doing that, does anybody need a break? Y'all good? Make 20 minutes? Okay. We're going my usual timeline. If we're going to go beyond, I just want to make sure they're okay.
I understand.
Go ahead.
So, as it relates to blood pressure, if someone's blood pressure is low, do you take that into consideration for the dose amount?
So the thing about blood pressure is that blood pressure, has kind of a specific purpose here, and that I need to actually have blood pressure to circulate the medicine. Okay? So a very kind of particular and graphic example of this is during chest compressions. So when people's heart has stopped, then one of the things to do, or the thing to do, is to, with your own hands, is to push on the chest. Okay? And by pushing on the chest, I'm actually creating blood pressure physically with my hands. Okay? There's something called open cardiac massage that sometimes is done in my area of cardiac, where I actually open the chest and reach in, and with my hand I'm squeezing the heart directly. But I don't always have that capacity, so in this case I'm just pushing on the chest. So, and when I'm pushing on the chest, I get a blood pressure. And when I get a blood pressure, it means that there's circulation and I can give medications. But if the blood pressure is low, then the medications that I actually give will not circulate. And so I have to give more of them in order to actually get an effect that can be, felt and be effective for the patient.
And once it circulates, does it start taking effect, or does it need to go somewhere else?
Well, it's got to circulate and get into all of the places that it needs to get for it to be effective. So it's not just a moment, it has to kind of, circulate around the body. And I can kind of see this, I can measure the blood pressure and so on and kind of see the effectiveness of what it is that I'm doing. Or in the case of pain control, I can kind of, gauge, we don't have any pain monitor, okay? There's no monitor I can attach to a patient and it says pain. You have to, this is the only monitor we have for pain is empathy, okay? And we use it to figure it out. So I look at the patient, I look and I see what they look like, and I ask myself, does this feel, do I experience this now as the relief of pain? Is that what I've achieved?
Can you get an accurate reading of a patient's pain or what they're going through at the time of death by looking at medical records?
Oh, no.
So how important is being at bedside?
There's no way to do this except to be at the bedside. You have to be present to know. Because in that description where I said, you could still be wrong. And so you've got to give more. Okay? So you got to be there to know when you give something, is it working? Is it effective? So you got to be right there.
What effect does, let me ask you this before I move on from blood pressure. Is that one of the distinctions between pain control with the dying versus pain control with the living?
Well, I think again that, pain control with the dying, you really only get one chance, don't you? Okay? Once a person is dead, and if you've done a bad job, you don't get a second chance. So in pain control of the living, which is at least a living person, let's say, a person who's more well and able to tell me, that can be something that can be some back and forth, where they're telling me, they're saying it's not sufficient. Again, I imagine that some of you, if every of you ever had any painful procedure or something and you're prescribed something, it may not have been sufficient. And so you complain and say, you haven't given me enough, or I need to do this in another sort of way.
And now I want to ask you about fluid in the lungs. When people have fluid in the lungs, is that something that is taken into consideration for dosing?
I mean, so fluid in the lungs, of course, is a very painful kind of thing. And as an example, like think about a time where you've had a glass of water or something, and by accident, a little bit of it, goes down, quote, the wrong hole. Okay, it goes into your trachea, and it's exceedingly uncomfortable to do that. Even the smallest amount of water, if it hits your vocal cords and into your trachea, you cough, you gasp, your vocal cords can actually spasm and shut tight, and you can't even speak for a moment. It's so painful and difficult an experience. So the airways are basically made for gas, for air only. And any time that there's water or fluid or secretions in there, it's very difficult, very painful. And so you want to make sure that in those circumstances that you're also using, a good amount of fentanyl or pain control to manage the pain, of how difficult it can breathe when you've got fluid in your lungs.
And now, what about fat? Does fentanyl like fat?
So fentanyl is in order for drugs to work, they have to kind of cross this sort of barrier, okay? Like they're in the circulation, and then they're moving along and have to kind of cross from one space to another. In order to do that, they have to pass a membrane, okay? And the membrane is composed of lipid, which is the fancy word for fat, okay? And the easier that there is, and that fentanyl, we call that drug lipophilic, okay? It means fat-loving. It's a funny term. But the idea of a fat-loving drug is that its uptake is more rapid and more quick. But the other problem, and so a drug like morphine, for example, when given, would have a slower uptake because we call that drug lipophobic or hydrophilic. It likes water. It's like the thing about water and oil, think of salad dressing, okay? The way the oil and the vinegar don't mix, okay? So like dissolves like, we say. Fats like fats and water likes water, but you can't mix them very easily. So the more hydrophilic a drug, the more loving it is of water, the slower onset it takes to get going. When a person is themselves obese, so one question is, well, how much do you give someone who's obese? Because there's something called like a ideal body weight or lean body weight, and it's a little bit unclear how much you should give. But generally speaking, when someone is obese, then they get more as opposed to less. In the circumstance of at end of life, where you're trying to make sure that they're getting enough.
Now you mentioned most people. When it comes to giving medication, this may sound like a silly question, but is everybody different? And how does that play into your role as a doctor?
I mean, everybody, of course, is different. Everybody's different. And sometimes the differences in terms of people, you can't tell by looking, okay? So, there you can picture in the bed, some very large, muscular man, whose pain control might be very poor, and he may need, very large quantities. And then picture, someone who's very petite and frail, and their capacity to endure it, might be much more. So this kind of, you can't tell necessarily by age, you can't tell necessarily by weight or gender or any other kind of thing. You've got to kind of look each individual, and you can't tell in advance. It's hard to predict. So I keep an open mind. I'm ready to whatever it is that I need to do, but everybody is a little bit different, and sometimes the differences, again, are not knowable until you kind of start in and start to do things.
Now, we've heard a lot about the combination of benzodiazepines with opioids. Is giving both benzodiazepines and opioids an acceptable practice?
Yes, it is.
Okay. Is it a common practice?
It is a common practice.
Does that include terminal extubation?
Yes, it's a common practice in terminal extubation.
Now, we've heard this phrase called synergy. how does that play into all of this?
So the reason, we've talked a lot about fentanyl and drugs like that and how they're specific for pain. Now, what fentanyl does not treat is anxiety, okay, which is a different kind of experience. Now, people can have pain and therefore get anxious about it, or they can have anxiety that is really kind of unrelated to pain. And so if someone, is purely anxious, I would not reach for fentanyl or morphine or any other opioid. And all the fentanyl and morphine in the world would not treat someone's state of anxiety. And by the same token, if someone is having pain, I wouldn't reach for a drug like midazolam, which really is specifically to treat anxiety. It would not matter. So if you picture the idea of dying and the experience, it's reasonable to assume that it produces two experiences: pain, because we've talked about it, and also anxiety, anticipation of death, which can very likely produce anxiety and fear in people. And so I'm trying to treat both of those things. And so that's why, it's not, synergy might mean that like one makes the other more effective. It's not quite right. Is that you're using two drugs that are distinct, but are working together to treat two separate problems.
So does 1 + 1 = 5?
Not that I know of. No, it does not.
Okay,
And
let's put that in context.
Sure.
So
Are you talking mathematically, or are you talking the effect?
The effects. I'm referring to the effects.
So fentanyl does not make midazolam work better. Doesn't make midazolam a more effective anxiolytic, like to reduce anxiety. And midazolam does not make fentanyl a more effective pain control. So they're not synergistic in that way.
Okay. Now, we've heard a lot. We've heard that there is no maximum dose as it relates to opioids and palliative care. Is that correct?
Yes.
Okay. Why?
Because the dose that is, the dose is really the effective dose. That's the dose. And because everyone can be different with how much they need, to use, the concern would be if you set some dose and said, you can't give any more than this, there will be most certainly someone who needed more and didn't get it, okay? And then that person would die in pain. And so we understand that this idea of, where we agree that there should be pain control, it's the practice is not to specify a dose per se, but to say, give what is needed, give what is effective.
And who determines that?
That's, clinical practice. I mean, if you look, for example, the American Medical Association has a statement on end-of-life care. And in their statement, they say, treat to control symptoms. And they don't specify rightly the drug nor the dose, because they understand that it might be different.
Is that on purpose, or is that just because somebody forgot to say there's a high dose limit, or this is the top and no one should go because that would be lethal?
That's based on the experience of doing this work, over, many, many years and many thousands of hours of combined practice of people. Like these things are gathered up by the practice. So, and that's how these positions are communicated.
So, is it based on your training, experience, and research that the reason there's no max dose is because it's patient-specific, or it must be what the doctor believes is appropriate?
I mean, it's obviously patient-specific. And it's also based upon, a doctor's, view as to how much they think a person can need. And, some people, like, I've met, doctors are not all on the same page on this, okay? Like some doctors, feel that pain, might give small quantities, and others give large quantities. And those that give small quantities might think that whatever, the patient doesn't need it, or the patient can manage without it, or have some other kind of notion about how much pain someone should get. Like I said, the easiest pain to bear is someone else's. So, I, as an anesthesiologist, I'm expert in the relief of pain, okay? And so in that way, I have a strong clinical experience with dosage and pain relief. And it's something, that anesthesiologists are particularly, plugged into and expert in.
I don't understand that there's no max dose, because we hear people overdosing all the time. Why is,
Sure.
how does that play a role with your opinion?
So, we need to acknowledge that we're living in a strange time with respect to opioids and pain. Ohio has not been spared the problem that is the opioid epidemic. I imagine that people in this jury may have known someone even who have died or who've become injured.
Sustained.
So I'm mindful to our reaction to opioids.
Okay. The objection was sustained. Your question.
Yeah. Tell us more about the issue of why. How is it related between medicine and people overdosing?
Right. So when a person overdoses on opioids, of course, clearly they're not doing that under a doctor's order. They've become addicted, and now they're seeking to try to control a very serious addiction, and that's what they're doing, and they make mistakes. When a doctor is taking care of you, of course, a doctor is regulating and titrating and feeding back on what your pain control is. So opioids are, when opioid overdose is self-administered, and it's not under the direction of a doctor, and it's under a very different kind of circumstance. It's a mistake, okay, and that's why that happens.
Is there another reason why people are overdosing on fentanyl?
Well, so it used to be, medicine's relationship with pain control, again, is a complicated one. And there was an edict, okay, that said,
A what?
an edict,
What's
like a declaration, okay, like a pronouncement, okay, that said, henceforth, pain control is a vital sign. So you have to do pain control, okay? Then if you don't, as a doctor, provide pain control, you're not practicing, proper medicine. It was a very big deal, okay? And so everyone, wanted to prescribe pain control. And so opioids were widely prescribed, okay, because people were concerned that if people were walking around with pain, that would be a terrible thing. Now, in our enthusiasm for that, of course, we failed to appreciate, the addictive nature of opioids. And that was a huge, tragic mistake. So then what happened was, okay, oops, we've made a mistake. We know we've addicted all of you. Sorry about that. We're going to now have a new edict. And the edict is, from now on, you can't give anyone with chronic pain more than this quantity. It was just a number. And it said, okay, no one can get more than this. Now, the problem with that is that many people were now addicted and required 2 or 3 times that dose. So now the doctor says, I'm not giving you any more, okay? And so what do you do when you're an opioid addicted person? Well, then you try to find it in other places.
Objection. Relevance.
Sustained. Let's tie into something else here.
I think this.
It's
Well,
a
actually,
good time for lunch. I got the idea that's where you were going. So, ladies and gentlemen, we get started back at 1. It gives you an hour and 10 minutes. Have a happy lunch. Remember the admonitions.
All
We'll
right.
see you back at that time. Have a great lunch, guys. Okay. You may be seated. Doctor, you're currently on the stand. You cannot discuss your testimony here today, how you testified, what you testified to. You can answer a factual question, but you cannot, it's not related on how you're testifying or something that you testified to. Do you understand that?
Yes.
You're excused till 1 o'clock. We're trying to move you out of the courtroom so we can talk. Not to be rude or anything. Don't go completely away, Mr. Baez. Anything for the record?
Nothing from us.
Nothing from the state.
Okay. You probably need to capture that too by a shot or something.
Capture. Yes.
Well, I'm just saying,
I'll put a sticker on it.
You put it out fair game, doesn't mean she can't mess with it.
Right.
But if you want to preserve it, I would say take a picture,
Okay.
because it's demonstrative in nature. Okay?
Yes, sir.
Miss, anything for the record, Mr. Baez?
No, sir.
Miss Mick?
No, Your Honor.
Okay, 1 o'clock.
We're here today to announce the results of an approximate 6-month investigation, a 25-count indictment against Dr. Husel for murder.
How did we get here?
Let me express my deepest condolences to the families.
You gotta be joking. It can't be. Why would he do that?
Here.
Okay.
A place where families are reliving pain.
We're all hurting.
Mm-hmm.
We're all horrified.
Here. A place where a doctor is accused of killing his own patients.
Dr. Husel, do you have any answers as to why?
No comment.
Is it fair that you're walking out of jail today?
No comment again. Sorry.
Do you have anything you can say to the dozens of families hurting right now?
Never did Dr. Husel or anyone on his team have the intent to speed up a patient's death.
How did we get here? In this series, we will answer that question and others and explain to you how we broke the story of the patient overdose scandal at Mount Carmel. The story of a lone doctor accused of giving his patients too much pain medication. It's much more than that. It's about a series of missteps, miscues, and miscalculations on the part of a health organization that helped contribute to a tragedy.
I was just wondering if you might have some time to talk with me.
So we called Dr. William Husel on January 14th. That's the same day we went on air with the story.
Have you already retained a lawyer, or is there someone I could call?
He declined to comment, telling me to contact his attorney. We had been working on this story for several days, acting on a vague tip that a doctor had been dismissed from the hospital. We were pushing our sources for more information, and we were able to get a hold of some internal memos from the hospital showing that the doctor had not lived up to the hospital's standards of care. The day we went on air with the story was the day that first lawsuit was filed. It was also the same day that Mount Carmel released a video statement.
Hello, I'm Ed Lamb, President and CEO at Mount Carmel Health System.
So Mount Carmel put out this video announcing that Dr. William Husel had been fired and that over 5 years he had ordered significantly excessive and potentially fatal doses of pain medication that had been given to 27 near-death patients. They all died. The hospital at the time also announced that it was suspending 23 nurses and pharmacists for their roles in administering these drugs.
On behalf of Mount Carmel and Trinity Health, our parent organization, we apologize for this tragedy, and we're truly sorry for the additional grief this may cause the families.
What we would later learn is that the hospital created a second video. This one was only sent out to staffers and, in part, laid blame.
Sadly, our investigation revealed that some of our colleagues did not meet our standard of care. The actions that created this tragedy were instigated by this physician and carried out by a small number of good people who made poor decisions. They ignored the safeguards we have in place.
So in that second video, Ed Lamb blame on the staffers, which is different from the video that was released to the public.
We take responsibility for the fact that the processes in place were not sufficient to prevent these actions from happening.
What we would later learn is that the hospital had been investigating for months, and that when it first learned of an allegation involving Dr. Husel's patient care, in between the time they learned that and when they removed him, 3 more patients died, something we would attempt to press the hospital on later.
Was there any chance to remove him prior to that?
Not before October, no.
No upper-level management knew prior to that?
No.
He shortened her life. He took her right to choose her death away. And I just feel that Mount Carmel should have stopped him long before this happened.
Albert Belisari's sister Joanne was a companion nun, very active in her church. Of all the patients identified by the hospital as being tied to the overdose scandal, Joanne Belisari was among the first. She died in 2015 and was the first to receive 1,000 micrograms of fentanyl.
It looks and appears to me you had a rogue doctor, you had a breakdown in protocols in the hospital.
Albert says he feels let down that a Catholic hospital would allow something like this to happen.
They're saying it's comfort, but when Joanne, she was out of the comfort zone. She was going to die anyway, and he didn't even consult the family before he inserted the fentanyl.
That process in particular, Albert says, about the drugs being inserted, he claims was not explained to him.
I'm angry, we may have consented if he had asked, but he didn't. He just chose it himself.
Another patient, Jan Thomas, died 2 months before Joanne in March of 2015. She got 800 micrograms of fentanyl.
Okay.
Reliving the loss of a loved one has been difficult for a lot of these families.
It just rips the wound right open again, so it hurts a little bit more this time.
The patients' families hired attorneys who sued Mount Carmel and Dr. Husel in wrongful death lawsuits. They claimed the doses were grossly inappropriate and that the hospital was negligent. Husel's attorney and those for the hospital have argued in court filings that these patients were in very poor health, or in some cases dying.
If his intent was not to cause them death, his intent was then to do what? What was his
comfort care? Comfort care. I think it's important that everyone watching this understand that the patients that we're talking about are end-of-life patients. These people were being kept alive primarily due to the equipment in the hospital.
Prosecutor Ron O'Brien used an analogy to sum things up. He said Husel's actions were akin to blowing out a candle while there's still some wax left over. A grand jury indicted Husel on 25 counts of murder because 25 O'Brien received 500 micrograms of fentanyl or more.
No one that says 500 micrograms of fentanyl is an appropriate use of fentanyl for treatment of someone being taken off a ventilator.
All of the patients were in Mount Carmel's intensive care unit, where Husel worked the overnight shift. Many families told us their loved ones were in bad shape, but they were convinced by Husel or others that their loved ones were dying or brain dead. Records show nearly all the patients got the drugs around the time their ventilators were being removed.
You know, you want to believe it's just a bad dream. and that it's not true.
Lisa Coleman recalled a conversation she had with Dr. Husel about her father, Jim Allen.
He said, I can promise you that he will not suffer and he'll go quickly.
Did they tell you that Jim was brain dead?
They said he was in complete organ failure.
That's what they told us.
That's basically what they told us too.
Yeah.
After news of the scandal broke, the Centers for Medicare and Medicaid Services steps in, sending state health inspectors to the hospital to find out what went wrong. They find in 24 of the 27 patient cases they reviewed that Dr. Husel used an override function on a medication dispensing machine to essentially bypass the pharmacy and gain access to pain medications like fentanyl. To the families and their attorneys, this is proof that the hospital's internal safeguards were not working.
This proves their negligence. It just proves to me that they weren't watching the ship. The records should speak for themselves.
The hospital says it first learned of an allegation involving Husel's patient care through a formal report that it received around October 25th, 2018. But it didn't remove Husel from patient care until November 21st. And during that period, the hospital got additional reports, and 3 patients died.
We want to know what that formal report was. We want to know what informal reports they had. Reality would tell us that somebody in this 4-year period of time was saying something about this.
Was the hospital aware before October?
We've been discovering things all along as we've been learning through the investigation process.
But was there any chance to remove him prior to that?
Not before October, no.
It's only after these lawsuits are filed and CMS steps in that we learn from Mount Carmel that some of the patients could have seen their conditions improve with other treatment. And we start to hear from sources inside the hospital who allege that this tragedy could have been prevented.
Hello, I'm Ed Lamb, President and CEO at Mount Carmel Health System.
The same week the news broke about the patient overdose scandal at Mount Carmel, the federal government steps in, sending state inspectors to the hospital to find out exactly what went wrong. How did these large doses of medication end up in the patients? By late February, the hospital admits that some of these patients could have seen their conditions improve.
We are aware of 5 cases in which this possibility is a concern.
All this time, we had been talking to Mount Carmel employees, some of them telling us key details. None wanted to be identified.
It is absolutely a systemic failure.
We did speak to one who worked directly with Dr. Husel.
He is well respected among the staff members. He is very calm.
The source says the allegations against Husel that he allegedly accelerated the deaths of 35 patients could be hard to prove.
The line between providing comfort and accelerating death is a very great one.
His criticism was aimed at the hospital, who he says erred in suspending nurses and pharmacists who helped administer or approve these drugs, saying they hadn't been trained properly in all the facets of ventilator removal and that the hospital's internal safeguards weren't strong enough. Husel's accused of ordering large doses of fentanyl and using that override function on a medication dispensing machine to bypass the pharmacy and gain access to the drugs.
So in other words, you could order, you wouldn't have to tell the pharmacy you were doing a ventilator withdrawal?
That's exactly right.
You could just say, I need 1,000 micrograms of fentanyl.
That is exactly right.
So the source says that Husel was very much liked by his colleagues and that he even helped train some of the people working in the ICU.
Did anyone challenge Dr. Husel over these high doses?
Now, Dr. Husel has been known to prescribe high doses of narcotics and sedatives. He has been challenged, and there have been verbal communications to managers about these things, but no one expected that these events had led to death.
Mount Carmel has said it did not learn of concerns about Husel's patient care until October of 2018, when it first began to investigate. But sources tell us that the hospital erred long before this, in 2013, when it first hired Husel.
The families need to know that, we could have prevented him from having those privileges and being on that floor, on that unit.
This source alleges that Dr. Carmel's own criteria to work as a critical care intensivist. We got a copy of Mount Carmel's application for clinical privileges, and in order to work in the ICU, you have to either be a DO or an MD, have completed a fellowship in critical care, a residency in internal medicine, and be eligible to take and pass the board exam in internal medicine. Husel met just 2 of those 4 requirements. The hospital said they got an outside legal opinion and that according to its own bylaws, Husel's skills were, but our source disagrees.
No, I think this is obvious. He should have never been in the hospital. We could have prevented 35 deaths.
Through our own research, we found out that the hospital was not aware of Husel's past convictions in 1996 on a misdemeanor charge of possessing a pipe bomb. They didn't learn about that until after Husel was fired in December of 2018. So how did that happen? Well, according to our sources, the hospital's background check only went back 10 years, meaning if he was hired in 2013, the background check would only have gone back to 2003 and missed the charges from 96 and the other charges from 94 when he was charged with breaking into cars. The state medical board knew all of this. Husel told them about it when he applied to get his license to practice medicine. But it was information that never reached the hospital. When they did learn about it in the days after his firing, the president of Mount Carmel West, Sean McKibben, and his wife called 911.
There's a situation with a physician that lives in Dublin that puts us at risk because my husband is the president of the hospital where he used to practice. And so we are, there's concerns about our security and our safety.
Husel never threatened anybody, but a hospital spokeswoman said at the time apprehensions were high. That's why those calls to police were made. Mount Carmel has said it wants to make corrections and that it does not want to have a tragedy like this happen again. So far, those details have only slowly been released through press releases that the hospital puts out or videos that it creates. The hospital, for the most part, has largely avoided direct questions from reporters.
We are an amazing health system, and that is the truth. Unfortunately, it wasn't the action of just one. We're talking about at least 40 people. 40 people, at least, knew. Somebody was refilling the Pyxis. All those vials of fentanyl were gone. The Versed, the Dilaudid. Somebody knew.
There are a few questions that remain unanswered. Why did this happen? Who knew about it? What did they know? And when did they know it?
Somebody knew after the 5th time, after the 10th time, then after the 15th time, and the 35th time.
Was the hospital aware before October?
We've been discovering things all along as we've been learning through the investigation process.
But was there any chance to remove him prior to that?
Not before October, no.
Mount Carmel administrators have repeatedly said that they were unaware that one of its doctors was ordering high doses of pain medication and that others were administering it to near-death patients. But sources tell us the rank and file knew.
Did anyone challenge Dr. Husel over these high doses?
Now, Dr. Husel has been known to prescribe high doses of narcotics and sedatives. He has been challenged, and there have been verbal communications to managers about these things.
Mount Carmel suspended 30 employees, many of them nurses and pharmacists, and submitted their names to their respective state boards for potential discipline. Documents sent from the boards allege that the nurses should have known these dosages were harmful. Mount Carmel admits its own internal reporting system led an employee to blow the whistle on Husel in late October. Remember, between October 2018, when the hospital said it first learned of an allegation involving Husel's patient care, and November, when they removed him from patient care, 3 patients died. And something else happened. Husel's name was included on a list of physicians who were re-credentialed and reappointed to the active medical roster. Critics say this illustrates another institutional failure, that the left hand didn't know what the right hand was doing.
The processes in place were not sufficient to prevent these actions from happening.
And while some responsibility, it has only communicated through news releases and videos it creates. They've claimed the prosecutor's office and their own attorneys have told them not to speak about the scandal. So when Mount Carmel ends up in the news again with additional tragedies, a deadly helicopter crash involving a partner agency and a Legionella outbreak, When two of these incidents involved internal failures, we still had questions.
Sean, I'm wondering, it appears as though you guys have gone from one controversy with the patient overdose scandal to this one dealing with Legionella. I'm wondering what role or responsibility administrators bear for that, for both of those.
You know, we're talking about the Legionella situation today. You know, if there's another time that you want to get together and talk about that, Samantha, I'm sure, can arrange for that.
Sure. I mean, we've asked that repeatedly. I just want, you guys have been rather sheltered from direct questions related to the patient overdose scandal. I'm just wondering if there's anything that you guys would care to share in regards to bearing responsibility for what happened, not only with that, but with this.
Yeah, I mean, again, we're here to talk about Legionella today.
He would not answer our questions. Dr. Husel has also said very little.
Dr. Husel, do you have any answers as to why?
No comment.
Is it fair that you're walking out of jail today?
No comment again. Sorry.
Dr. Husel's medical license has been suspended, his Medicaid provider agreement is on hold, and now he's facing a murder trial accused of ordering too much fentanyl for 25 of the 35 patients who died under his care.
So what do you say to that?
Just trust the process.
Do you trust the process?
Yes.
Do you feel that in the end you will come out not guilty?
Hope so.
Never did Dr. Husel or anyone on his team have the intent to speed up a patient's death.
These were conscious decision-making orders by the physician.
Attorney Jerry Leesburg and his firm represent 17 of the patients' families suing the hospital and Dr. Husel, including 2 patients who died within hours of each other, Timothy Fitzpatrick and Beverly Schertzinger. In Fitzpatrick's case, something unusual happens.
He asked for 1,000 micrograms of fentanyl to overdose a patient and was told by the pharmacist that they didn't have enough fentanyl and that they would therefore request that if he was able to accomplish what he needed to accomplish with 500 micrograms, if that was sufficient. And he said yes. So he took 500 micrograms and gave it to one patient, and then he took the other 500 micrograms and gave it to another patient.
The other patient to receive 500 micrograms of fentanyl that day was Amy Paff's mother, Beverly Schertzinger.
The pharmacy didn't have enough fentanyl. That's an issue. Why do they not have enough fentanyl? Because this doctor keeps giving them to these patients. You know, the fact that he gave it to one patient and then gave it to another, and it's upsetting.
Just the estate of Ryan Hayes.
While the hospital isn't saying much publicly these days, it is quietly settling some of the cases involving these patients' families. So far, the hospital has paid out roughly $4 million, including $485,000 to the family of Ryan Hayes, one of 2 patients, to get 2,000 micrograms of fentanyl.
We don't really have any evidence, for example, that Mr. Hayes was going to survive regardless of Dr. Husel's intervention.
Even though the attorneys acknowledge their client may have died anyway, that hasn't stopped these settlements from coming in. I asked one of the attorneys if that fact creates a defense for Dr. Husel.
He did something criminal, and it's really not about the survivability so much of these patients. It's really about lack of oversight by the hospital system and by his criminal actions in prematurely terminating these patients.
Any explanation you can give on behalf of the doctor?
Not right now.
When you say not right now, when will that be?
Well, I imagine there's going to be a trial.
A criminal trial that could last 8 weeks.
We're talking about the ability to exonerate him and the ability for me, as his lawyer, to appropriately defend him without compromising an ongoing murder case.
Attorneys for Husel and the hospital want a judge to place additional civil lawsuits on hold while the criminal matter is still pending. But attorneys for the patients' families have said there's still a lot of work to do. They want to interview the nurses and the pharmacists, and they want to review hospital policies.
I think it's very important to find the root cause of why did this happen? How did it go on for 4 years? Once we determine that root cause, that's going to be important for all hospitals to incorporate that and to make sure this doesn't happen at some other hospital, some future date.
Even with a potential criminal trial and dozens of wrongful death lawsuits, it may not answer all of the questions. We may never learn why. We do know how we got here.
For the first time since the scandal erupted, we're hearing from nurses and pharmacists about what happened inside Mount Carmel Hospital that led to the firing and later criminal charges against Dr. William Husel. Husel has pleaded not guilty to 25 murder charges, accused of ordering potentially fatal doses of fentanyl for his patients.
But in sworn video statements filed as part of the civil lawsuits against the hospital, nurses and pharmacists paint their own picture of a well-respected doctor who treated dying patients and a hospital that allowed for easy access to powerful painkillers. Here's Chief Investigative Reporter Bennett Haverly.
I believe I've already answered the question.
Ma'am, it's not for you to say. Is that your answer?
My answer is that the medications that I gave my dying patients were not harmful to my patients.
And
They were comfort care medications to keep them from feeling themselves suffocate to death.
This exchange between former Mount Carmel nurse Jamie Burke and a lawyer representing the patients' families helps illustrate the conflicting viewpoints about what happened inside Mount Carmel Hospital that led to lawsuits, firings, and a doctor being criminally charged with his patients' deaths.
Do you have anything you can say to the dozens of families who are hurting right now?
I'm going to have no comment for all your questions.
Civil attorneys and the county prosecutor allege that Dr. Husel ordered excessive and inappropriate doses of fentanyl for the near-death patients under his care. But in sworn depositions obtained by 10 Investigates, some of the nurses who worked alongside him tell a different story.
Did he ever suggest to you that or insinuate in any way that these drugs could in fact hasten death?
He told me that his intent is comfort care.
Former Mount Carmel nurse Jacob Deemer told attorneys that he asked questions of Husel about high doses, but Husel told him that there was no maximum dose for fentanyl when a patient's ventilator is being removed. Many of these patients under Dr. Husel's care were said to be in poor condition. The central question that's being debated, did the large doses accelerate their deaths?
I certainly did not want that to occur. I didn't want harm to occur. So when you turn on the news or you see something and it says, 35 people were running a kill camp, that just makes me upset. And I know that's not my truth.
Some of the nurses allege these patients were dying anyway, and that the drugs were meant to lessen the severity of those final moments.
So now he's going to be palliatively withdrawn. I'm going to take away his breathing, take away the pressure that's keeping his lungs open, his PEEP. I'm going to take all of that away, and he's going to be on room air. He's going to suffocate to death. So 500 micrograms of fentanyl was not a large amount at all.
Mount Carmel Health System has paid out nearly $14 million in legal settlements to the patients' families who sued after they were told by the hospital that their loved ones may have been given too much medication. Several lawsuits remain pending. These video depositions are part of that ongoing legal fight. We obtained them through the courts before a judge ordered them sealed.
We've heard dosages of 500, 600, 800, 1,000. Were you aware in the community there of the nursing that he used those kinds of dosages of fentanyl prior to extubations?
Yes.
Okay. Did everybody know that?
Yes.
Former Mount Carmel nurse Mariah Baird and Husel got married after the two met while working in Mount Carmel's ICU. Baird and many other nurses deposed as part of these lawsuits also face potential discipline from the state nursing board, in part over failing to question the medication orders. Baird was the nurse responsible for caring for patient Jan Thomas.
Did you have any concern at the time of Jan Thomas's extubation that 800 micrograms of fentanyl could in and of itself cause death?
800.
Form. Go ahead and answer.
800 was an appropriate dose for my patient.
How these doses were accessed has also become a central focus for the patient's attorneys. Health inspectors who reviewed hospital records found that Mount Carmel's pharmacy was often bypassed by nurses who used an override function on an automated medication dispensing system, or AMDS, to quickly gain access to large doses of fentanyl and other drugs that were given to patients as they were taken off ventilators.
When I was in orientation, I was taught that everyone was overriding.
Nurse Stephanie Lachard and others testified that overrides were common in the ICU. Pharmacist Gregory Driesbach also noted it, saying he raised concerns to his manager about the high doses being accessed via override. Initially, Driesbach said he thought people might be stealing the drugs. He rejected an order of 1,000 micrograms of fentanyl meant for patient Rebecca Walls. The drugs, he said, were later given to her anyway.
That had to be of some concern to you.
It was.
Driesbach fired off 2 emails to pharmacy managers in the fall of 2018. It was the day after Walls' death that he learned of an even larger dose of 2,000 micrograms of fentanyl meant for Melissa Penix, which Driesbach said drained the intensive care unit of its entire supply of fentanyl.
If you remember earlier, I stated that when they give these doses, it drains the machines upstairs of all the medication. So in this case, it drained both machines of all the medication. So they asked me to send someone up urgently to refill them because they needed fentanyl for patients that were in the unit. I said, just take from another machine until we fill it. And they said, we used both machines, the whole stock, on a pallet of extubation earlier.
And that had to be shocking and alarming.
Objection.
Objection.
Yes?
It was unusual, yes.
Shocking and alarming?
Objection. Asked and answered.
Were you shocked and alarmed when you learned that a patient had received?
Yes.
You'd never seen that before?
Not a dose like that, no.
Husel's privileges about a week and a half after that email from Driesbach were revoked, and Husel was fired in December of 2018. He has since filed his own defamation lawsuit against the hospital, alleging that the hospital rushed to judgment and failed to thoroughly review the medical records of the patients. The hospital has denied that narrative. We were not able to get a hold of the nurses, but an attorney who represents them declined to comment today. Husel's trial is set for 2021. Reporting live in Columbus tonight, Bennett Haberly, 10 Investigates.
Bennett, thank you. If you'd like to go back to the beginning and read up on this case with Dr. Husel, just go to 10tv.com/.
You can get right over there.
Yeah, thank you. Please be seated.
Good morning, ladies and gentlemen of the jury. How are you today? It sounded like it was a bit festive in the hallway. Okay, we're going to move on to the next phase of the trial. This is the opening statements. It's what the lawyers think it's going to be. It's like the trailers at a movie theater. They're going to tell you what they think the evidence is going to show. It is not evidence itself. That'll come in the next phase. But with that, Mr. Zion, are you ready to proceed?
We are, Your Honor.
Ms. Grubb, I'm sorry.
Yes, thank you.
Okay, before you get started there, if you all are comfortable, you can. As far as the mask. As far as the mask?
Because
you're in your own little cubicle there. Okay? I want you comfortable. Now, when you go, you got to put it back on. Okay? Sorry about that, Ms. Grubb. You may proceed.
Thank you, Your Honor, defense team, colleagues, and members of the jury. Good morning. My name is Janet Grubb. It is my pleasure to finally address you this morning. Mount Carmel West Hospital was an unlikely crime scene. The hospital formally opened in 1886, having secured the services of the Sisters of the Holy Cross. The training school for nurses was opened in 1903. The first graduates received their diplomas in 1906. 8 sisters were included in the class. The school still exists today and is now the Mount Carmel College of Nursing. This location was known as Mount Carmel West and was one of the 4 facilities that comprise the Mount Carmel Health Systems. Mount Carmel West moved in 2019 and is now known as Mount Carmel Grove City. Mount Carmel Health System is the second largest healthcare system in Central Ohio. Our evidence will show that they employ approximately 9,000 total employees and over 2,000 doctors in their numerous and their 4 hospitals. Mount Carmel East near Reynoldsburg, Mount Carmel Grove City in Grove City, Mount Carmel St. Anne's in Westerville, and Mount Carmel New Albany Surgical Hospital in New Albany comprises the system. Mount Carmel Health is owned by Trinity Health, a Michigan corporation. The Hospital of Mount Carmel West occupied a unique position in the areas of west and southwest of downtown Columbus, including Grove City and other small towns in the region. The hospital's ethic and profile fits the patients it served and the people who worked there. Hardworking, family-oriented, religious, trusting, generous. If you grew up in this area, chances are you stayed there. This is a painful family affair with no end of pain on so many levels. Our evidence will further show the pain relates certainly to the loss of the lives, who we will prove were murdered by the defendant, but also extends to the loss of careers, jobs, friendship, financial security, and trust in healthcare professionals and institutions. The evidence will reveal that this case unfolded one surprising step after another. The pharmacy staff at Mount Carmel West became alarmed about certain drugs ordered and administered at the direction of William Husel. Their concerns were escalated to hospital administrators, other physicians, and ultimately to the top medical officer at Trinity Health. The setting for the use of these drugs was the night intensive care unit at Mount Carmel West. These medications are powerful, potent opiates, benzodiazepines, and paralytics employed in the treatment of seriously ill individuals who are placed on ventilators to help sustain their lives. The evidence will show that these drugs were prescribed in massive doses in combination with one another. During the ongoing COVID-19 epidemic, we became aware of the use of ventilators to care for people needing life support. Being on a ventilator was not and is not a death sentence. People do come off of them and live. Unfortunately, that was not the case for the victims in this prosecution. The medical testimony in our case will demonstrate that when an individual is placed on a ventilator, they should be highly monitored and expertly managed to determine their physical state and to preserve life. This is a highly dramatic event in a person or a person's loved one's life. There are no guarantees when you go on a ventilator. If you are conscious going on a ventilator, you must know that you may never wake up alive again. This is the state in which we find our victims. Our evidence will establish that many of our victims were elderly. Some were younger than 40. They had multiple medical conditions. Many were extremely serious. They had families, lives, and people who cared about them. They went to the hospital for help. Several of them were not sick enough that they were destined to die during their hospitalization. They all had one thing in common. William Husel was the nighttime ICU physician who ordered lethal levels of drugs or a combination of drugs with their removal from a ventilator after their loved ones made the excruciating decision to withdraw care and remove them. A fair question would be, how did this happen? These drugs were obtained through Mount Carmel West's pharmacy system from a drug dispensing machine known as a Pyxis machine. They were located in the ICU. Often, Husel ordered drugs verbally and overrode the hospital's procedures for pharmacy review. At the time of the majority of these cases, in order to be within hospital policy for an override, it would either need to be an emergency situation, which our evidence will show is typically not the situation with an extubation, or Husel would need to witness the drug's administration himself. These drugs were removed in massive amounts, well exceeding reasonable dosing for the procedure of removing ventilator support. Physicians trained in their use will testify that the doses used were at levels that could not be supported by the patient's medical histories or current circumstances. They will further testify that the drugs ordered by the defendant caused the death of the victims as alleged in the indictment. The nighttime ICU at Mount Carmel West did not have a dedicated pharmacist. 2 pharmacists served the entire hospital during the night shift. If a physician ordered opiates or benzodiazepines on override from the Pyxis machine and the drug was administered, there was never pharmacy review for appropriate use. In the case of defendant's dosing regimens, his practice of overprescribing fentanyl and other drugs continued without oversight for years. You will hear how well-respected defendant was at Mount Carmel West. The nurses, pharmacists, and other doctors liked him and thought he was a good doctor. He was attentive to the patients and willing to share knowledge. Doctor of the Year honors were bestowed on the defendant during one of his first few years at the hospital. He was well known for his training at the Cleveland Clinic in anesthesiology and critical care. He was and is, in many cases, still highly regarded by many of the young nurses who worked on the ICU at night. Many new nursing school graduates, ambitious, bright, and in the defendant's thrall. They looked up to him, trusted him, and had extreme difficulty in questioning his orders or methods. His ability to verbally provide alleged reasons for his dosing, coupled with his training as an anesthesiologist, caused the nurses and pharmacists to accept his practices as appropriate and even essential. Our evidence will dispute his reasoning through our experts' explanation of the proper standards of medical care. Members of the jury, this case is a mountain of evidence, information, technical data, and criminality against 14 innocent and seriously ill individuals. Our evidence will show that this case is not about the following. It is not about fentanyl as a drug of abuse. It is not about drug diversion from a pharmacy. It is not about Medicaid fraud. It is not about a hospital system desperate to survive. It is not about taking comfort care from the dying or wanting people to die in pain. It is not about assisted suicide. It is not about criminal behavior of anyone other than the accused, William Husel. It is not about civil judgment for or against anyone involved in this case. It is not about wrongdoing by Mount Carmel as an institution or its employees, including administration, nurses, and pharmacists. This case will touch upon the following concepts: medical malpractice or negligence, group dynamics in the medical profession, financial pressures in the U.S. medical system, system failures in large institutions, the culture in the ICU at Mount Carmel West, the assumption in a medical setting of good intentions, the Catholic Church principles of sanctity of life and care for the sick, needy, and/or elderly. Our evidence will demonstrate that this case is about the following: standards of medical care, the rights of the critically ill and their families, including right to self-determination, right to the truth, and right to sit vigil over the dying as they progress towards the time of their natural death. It is also about the properties and interactions of powerful drugs, including opiates, benzodiazepines, and paralytics. We will demonstrate that our case is also about the science of maintaining the critically ill in an ICU setting, including appropriate pain management as used by other physicians at the hospital. It is about the science of managing pain within the palliative withdrawal of care, including removing a patient from a ventilator and controlling their pain and or agitation upon withdrawal of care. This science includes concepts embodied in a set of orders maintained at the hospital and used by other ICU and palliative care physicians. Similar dosing practices comprise the standard of care in the medical profession. You will hear how these medication regimens used by other physicians involve opiates and benzodiazepines in a much lower equivalent doses. Mount Carmel's palliative ventilator withdrawal order set, in existence for all of our 14 cases, but the first, recommended a pre-dose of 5 to 10 milligrams of morphine before extubation and adjusted amounts after extubation to keep the patient comfortable. It also suggested 2 milligrams of Versed, a benzodiazepine for agitation or anxiety. Oxygen therapy was also suggested. The conversion of morphine to fentanyl is roughly 10 to 1. Translated into fentanyl, the pre-dose would be 50 to 100 micrograms. Defendant administered 600 to 2,000 micrograms at one time. The defendant's pre-doses were 6 to 10 to 20 times the recommended dose of fentanyl, depending upon the patient, and 3 to 5 times the dose of benzodiazepines. The state's evidence will further show that opiates and benzodiazepines have a synergistic effect and create a medication multiplier, not a simple 1 + 1 = 2. This combination of drugs creates an overwhelming risk of respiratory depression. Our evidence will also show that after an extubation, the standard of care involves maintaining a caring presence at the patient's bedside, monitoring pain, and ongoing titration or adjustment of the medications to keep the person in a state of comfort, allowing them to pass naturally. This is in direct contrast with the defendant's practice of administering an enormous shot in a short period of time and calling it a day. Our evidence will also show that Mount Carmel Hospital System ran an internal audit, and the defendant was the only physician in the entire hospital system using fentanyl and benzodiazepines in these grossly inflated doses for this purpose. Ultimately, our case is about the fact that William Husel caused the death of our 14 victims. You will hear and see for yourselves the way this case was referred to the Columbus Police Cold Case Homicide Squad and Franklin County Prosecutor Ron O'Brien. Police involvement came on the heels of the Mount Carmel Hospital internal investigation or review of the defendant's dosing practices. The hospital's review was separate from the police investigation and resulted in the termination of Husel, pharmacy staff, and nurses. These concerns were eventually directed to his practice when he ordered the removal of people from ventilators, supporting their breathing, along with other life-preserving therapies. These homicides are loosely classified as cold cases. The reasons for that are the period of time between the death and the suspicion of foul play. Most of William Husel's victims died without any question regarding the reason for their demise. Fortunately, we have the actual medical records for each of the deceased. The records demonstrate as much relevant medical information as possible, short of an actual autopsy. Based on the drugs administered involved in these cases, the evidence of death and why they died will be clearly proven by the state's evidence. The state of Ohio will present a number of mainstream medical experts. All of them possess special certification in their medical fields. Many of them publish in their fields and teach other physicians in order to educate the next generation of practitioners. They have years of relevant experience and will testify that William Husel's dosing practices were unwarranted and unprecedented. The state's experts will establish that our victims' medical situations fall into several categories. Many were not in a position to feel discomfort, pain, or agitation. Nonetheless, they were administered large doses of fentanyl or fentanyl and benzodiazepines without being medically indicated. Several of our victims should have been maintained on life support for a longer period in order to eliminate all possibility of hope and to be observed. Others of our victims could have survived with appropriate care and informed decision-making by families. In this case, we will demonstrate that because the defendant was not acting in good faith and used drugs wildly excessive for the needs of his patients, this defense does not apply. We will present testimony from numerous physicians, nurses, and pharmacists employed at Mount Carmel West at the time of the murders. These individuals played a part in the events detailed in this case. They are not accused of criminal conduct. In each instance, the defendant ordered the administration of the lethal doses of medication. Our evidence will establish William Husel's actions caused the death of these patients. As we previously discussed, these people were quite ill and receiving care in an intensive care unit. The state's experts will establish that not all of these people were terminally ill on the date of their death, or at all during their hospitalization. We will prove that William Husel's acts were a cause of their individual deaths. We will prove through our evidence, all consistent with Ohio law, that the defendant is responsible for all of these deaths as the natural consequences of his unlawful acts, even though the victims had serious illnesses. The state does not need to prove the defendant's motive. However, his purpose will be very clear. The state's witnesses will demonstrate through actual, detailed medical testimony that given the physical condition, medical status, ages, and previous course of treatment of his patients, Dr. Husel knew exactly the natural result of his purposeful acts, and that therefore he possessed the intent to unlawfully end the lives of 14 innocent individuals. As William Husel possessed advanced training in the use of the drugs he employed to end the lives of his patients, the state will show that his actions were not mere accidental or medical negligence. They were, in fact, murder. The drugs used and the size of doses used in conjunction with other powerful drugs were important elements in determining his intent. But other behaviors were important too. These behaviors include what events were treated as emergencies or urgent, the timing of these procedures, the time of day of these procedures, how consent to proceed to comfort care was obtained and from whom. Other factors included the actual medical condition of the people that were murdered, and that some of the murdered could have left the hospital to go home or to hospice. As previously discussed, this case has many heartbreaking aspects, none more so than the loss of the patients of William Husel listed in the indictment. These people had names and families. Joanne Belisari, Ryan Hayes, Beverly Schertzinger, Danny Millette, Francis Burke, Brandy McDonald, Jeremiah Hodge, James Allen, Troy Allison, Bonnie Austin, James Timmons, Sandra Castle, Rebecca Walls, Melissa Penix. Members of the jury, thank you for your kind attention. We assure you that our case will provide all that you need to consider this case fully and to deliberate with confidence. The actions of the defendant speak clearly to us. After careful consideration of all of the evidence, we are confident that you will return verdicts of guilty against the defendant in all 14 counts. Thank you, Your Honor.
Thank you, Ms. Grubb. Mr. Bias?
Of the jury.
Your Honor, we need a moment to set up. If we could take a quick 5-minute break.
Well, if I give them 5, they won't love me anymore, so how about 10? Will that give you enough time? Let's take 10 minutes, ladies and gentlemen. Remember the admonitions?
All right.
We'll get started back here in a second. Ready? Yes. We're back on the record. We had left off with, I think, 24.
Yeah, Judge, we have Pyxis logs for everyone, every single patient. We did not, I thought we had an agreement as to their admissibility. Apparently we did not. We did, however, show, because, they're part of the medical records, but that, the pharmacy records anyways, but, so we did show for the Pyxis logs. I guess we'll just try to submit then, since we don't have an agreement on all of them. Where's the page? So 24A, 24E, 24J, 24K, and 24M. Those were the Pyxis logs that were shown to witnesses. 24A, which is Belisari, was shown to Dresba. 24E, which is the Pyxis log for Brandy McDonald, that was shown and identified by Schroyer. 24J was shown to Schroyer, that's the Pyxis log. That's the Pyxis log for Bonnie Austin. 24K was shown to Talon Schroyer. Oh no, we're at J. 24K, which is the Pyxis log for Jack Timmons. and that was shown to Taylor Schloyer. And then 24M, which is the Pyxis log for Rebecca Walls, that was shown to Greg Dressel and Jordan Blair, identified as fair and accurate, and a business record. It is probative and corroborative of their testimony. So we didn't show the other ones, but they are all the same things. But
Can I see those?
What?
May I see those?
Yeah, you just want the pertinent ones, Judge?
Just the pertinent ones you're seeking admission,
All right.
since you didn't show the other ones evidently.
Yes, I got sort them out here. So here's 24A. Here's 24E.
Or can just give me a heads up when I can respond. I know you want to review them first.
24J, Judge, it's just one page.
So I have 3 pages, 3 exhibits.
I got some more for you, Judge.
Okay.
K and M to give you too. Here's K. That's for Mr. Timmons. And then we've got finally M, which is the Pyxis log for Ms. Wells.
And those are the 5 you seek admission.
Yeah, we didn't, those are the people that we could identify that went through.
Your Honor, none of the 5 people that were shown those records have any responsibility towards maintaining them. None had indicated they had seen them before. In fact, the only person who's referenced any responsibility towards Pyxis logs was actually Mr. Miles, who testified that prior to the dates in question in this case, it was part of his responsibilities back then to have run these Pyxis logs and audits to look for diversion. The person who actually was responsible for compiling these logs and maintaining them has not testified in this case. Every person who has shown them, and doesn't necessarily mean they can authenticate it, just simply said that it reflected what they understood occurred, but doesn't authenticate what would be a cumulative and non-authenticated record where the jury's already heard God knows how many times about the doses that were given, whether they were done via override or not, to submit these Pyxis logs containing a series of irrelevant information that were never authenticated, not made by any of these witnesses, nor maintained or even viewed by any of them prior to being given or shown them by the state prior to them taking the stand, doesn't mean that they have the means of which to authenticate them as being accurate or to having produced them themselves. So there's a host of evidentiary issues regarding that because, again, they didn't make them, they can't authenticate them, they had never seen them before the state showed them before they testified to it, and at their best there are summaries in which the person who created them has to be able to testify to their validity. Just because the state showed the log to the witness doesn't necessarily mean that self-authenticates itself because they say, well, yeah, that's my recollection that it was an override and it says override on this log. They bear no relevance, no authenticity by any witness at all. In fact, Jordan Blair for 24M said he had never seen it before on the stand. And at the absolute best case scenario, it's overtly cumulative of all the evidence that already has come in. They're going to get the medical records. They're getting the quote-unquote MARs for every patient. They don't need non-authenticated Pyxis logs to cloud the picture.
Are they part of the medical record?
No, Your Honor.
Why not?
Because they're not contained in a single complete medical record Those are essentially logs taken from the machine itself to indicate what was done and why. They're not actually medical records. They're it's a system, an automated dispensing system, and its own internal logs as to what occurred. It's not has nothing to do with actual medicine, so much so as it just has to say this person executed this action on this day, which they all testified to, independent of the not authenticated logs.
So it's a summary of the medical records?
No, Your Honor. It has no bearing to the medical records. That's why after...
I'm trying to understand here, because throughout this trial, we've heard about this list of medications, and it's been used on every witness.
They don't correlate.
Isn't this basically a summation of all those?
No, Your Honor. They don't correlate. That's why, if you've heard from the testimony of the nurses, that when they actually take it out of the Pyxis log, they then have to go enter it into the computer, which would then become the medical administration record. That's actually the EMR, the electronic medical record, those MARs, the medical administration records. What's done in those logs is essentially just a computer keeping track. It's the equivalent of a vending machine telling you someone bought a Snickers on a certain day and how they did it. It has nothing to do with actual medicine, so much so as it's just a machine telling you what was dispensed and when and by who. That has nothing to do with the medical records, and that's why it's called a Pyxis log, and it's not contained in any of the single medical records. There's no reference to the Pyxis logs in a single one of the tens of thousands of pages that are there. They're wholly separate and apart, and thus needed to be authenticated by someone who could say they knew how that report was generated. They themselves generated it. It was done in an authentic and reliable manner, not just showing it to someone and saying, hey, does this reflect your recollection of what occurred regarding an override for this patient?
Mr. Zion?
Well, Judge, I don't think you would have let us show these to the jury like we did if the witnesses couldn't have authenticated them. My memory is that they authenticated them and said, yes, those are Pyxis logs. Those are fair and accurate. They kept in the usual course of business. So I don't think authenticity is really an issue here. Those were, in fact, shown to the jurors. Judge, we just didn't show them to the witness and then not show them to anybody else. So, of course, we went through the appropriate business record exception, and they did authenticate as fair and accurate before we published those to the jury. They are part of the medical record. They are a corollary part, and most importantly, they show that, which is a major issue in this case, how this medication was obtained in those cases via override. So, one of the questions that was asked is, where was pharmacy? Pharmacy was unaware, and you can see it all in that with those overrides done. So it's relevant. They've been authenticated, and we'd ask for their admission. Thank you.
Not a single witness that said that's a business record that could be kept in the ordinary course had the means of which to testify to that, because they don't maintain those records. And in fact, the person who does, who you know is not any of those witnesses, never testified, and Randy Miles even testified that individual took over for him during the relevant time periods for this case. Those the Pyxis logs and audits were run for a very particular reason, and simply saying that because a witness took the stand and said, yeah, that's a Pyxis log that you showed me 3 days ago, doesn't mean it's so. Just saying, yeah, that's what you showed me 3 days ago, and it's a Pyxis log, and it says Pyxis log. Doesn't mean that they actually pulled the log themselves, created it, maintained the machine, or can testify to anything regarding it, whether it's a business record or not. It's the equivalent of me showing someone an apple a week before they take the stand and saying, hey, is this an apple? Doesn't mean they grew it. Doesn't mean that they produced it. Just means that they were shown it a week before, and that's the same thing they were shown a week before. Doesn't all of a sudden eviscerate the rules of evidence that a person has to actually have the means to authenticate something as being fair and accurate. And just to clarify, Your Honor, if they're actually medical records, they would be in the medical records.
But aren't they in a different format?
No, Your Honor, because it's a distinction between, for instance, those have waste and things like that, where drugs that are not used or have to be put back in and demonstrated as waste, where that's not in the medical records, things like that. It's a mechanical administrative record that has no bearing to the actual dosing the medicine, if it was given or not, or anything. It's quite literally a vending machine's records.
Okay. I will not admit them or let them go back to the jury. They are part of the record. I do feel there's a foundation issue with that ruling. Next.
I didn't hear your ruling, Judge. You're
I said that I felt there was a foundation issue.
Let's do it.
Because you're trying to do it as a business record. 3 questions weren't answered.
3 questions for an answer? Is that what you said?
There's 3 basic questions to a business record. I don't know why I'm suddenly not able to be heard.
I can't.
I said, I have a problem with the foundation. I don't think you met the criteria for a business record. Therefore, they're not admitted.
Okay. 25 is the notice of settlement between Board of Pharmacy and Mount Carmel as agreed to by the defense, page 1 through 7.
We are not agreeing to that, Your Honor.
Oh, well, you were the one that agreed to it, so I'm sorry.
We are not agreeing to that, Your Honor. To
Did
clarify,
you agree to it before?
not to my knowledge for its admission into evidence.
Let me see it.
Sure, Your Honor. First of all, it's the clear definition of remedial measures. It's a settlement agreement between the pharmacy and Mount Carmel and Randy Miles. And I'll point the court's attention to the language that says aggravated patient, that's for pharmacy standards. So not only does it invade the province of the jury, it's a remedial measure that has no relevance whatsoever to this case.
I'll let Ms. Grubb, she talked to Diane about that. That was like a 50-page document, and I thought they had all agreed when they put Mr. Miles on, which these other pages that could go back. I must have misunderstood.
I showed, Your Honor, I showed it to the legal counsel. She reviewed it. I said I'm going to publish it. She said, okay. But the parts of it that she thought were favorable to them or helpful. And it was published to the jury. So, and there we have it.
Your Honor, this is, I think, now the argument that my co-counsel has made that we're bringing before the documents that relate to remedial measures, which would be analogous to lighthouse information, seems to be inconsistent with the court's ruling. This is clearly a remedial measure. Whatever information is or isn't in there, I don't certainly disagree, though, with Ms. Grubb's assessment that the initial document was probably 25 to 50 pages long. I don't really remember, but it was of substance. I think it was attached was all the things they agreed to do, and those were taken out. I must confess, it's been a long few weeks, but we would object to it on the basis of the court's ruling with respect to remedial measures and lighthouse and et cetera, Your Honor.
Other than the fact that the witness testified to it without objection, the jury heard it, it was published. I did a lot.
I understand all that, but it is a remedial solution that occurred there.
Yes, that was,
You could do blood type, I think was it, right?
yeah.
Yeah, it was blood. All right, 26A is the NCH approved list of medications in Lexicon literature.
Because the science was bad.
Are we ready? All rise.
We don't have a basis to object to it.
So, admitted without objection.
We'll continue on. I hope, ladies and gentlemen,
Is the Mount Carmel policies and procedures.
Good afternoon, Doc.
Good afternoon.
We didn't meet during the break, correct?
We did not.
Okay. Sent you off on your own, did I?
You did.
Okay.
I want to talk a little bit about your bioethics background and how it relates to the doctrine of double effect.
Okay.
Is the doctrine of double effect applied in palliative care, in palliative withdrawals, and palliative care?
I think the answer to that is no. It really isn't.
And is there a debate on that?
There is certainly a debate on that. There is.
And is that because death is an intended result or an expected result?
I think that one of the problems of the doctrine of the double effect is it's also kind of overly simplistic, of the way it tries to kind of explain the problem. But yes, at the end of life where death is expected, it's arguable that it may not strictly apply.
Okay. And has it been argued that it applies in the dosage, in the use of opioids?
The struggle with the doctrine of the double effect is this idea that when something is done, there can be two effects. One effect is positive and one effect is negative. And if the positive effect exceeds the negative effect, and the positive effect is the intended effect, then according to this doctrine, it's okay to do it. So I think that the doctrine of the double effect, though, of course, doesn't say anything about specific dosages or specific drugs. It's just really, it's a broad idea that's, an old idea, but that's basically what it is.
Is it also utilized in the context of the pain being the bad?
Yes, so, I think that pain, when people think about the doctrine of the double effect, classically, it's the idea of having two effects that are present. And so one way to configure it would be that the desired effect is to relieve pain, and the undesired effect would be that pain would remain. And so it would be, again, one is seeking, I suppose, the positive effect, which is to relieve pain, but understanding that the negative effect might be that pain is not relieved. Again, it's a very broad kind of concept that I think probably oversimplifies, really what is actually happening around these kinds of conversations at the end of life.
Is it fair to say that it's utilized in lots of medical peer-reviewed literature?
People, we always are trying to kind of do basically it actually is kind of suggested in basic bioethical conduct, okay? And so there's something in bioethics which is called which is described as 4 principles, okay? The 4 principles of bioethics. And these things go like this. The first principle is to do no harm. And we call that, the fancier name for that is the principle of non-maleficence, okay? Number 2 is the principle that is to do good. And that's one's called beneficence. And then there are 2 others. Number 3 is the principle of autonomy, that a patient has a right to kind of rule themselves. And number 4 is something called social justice or distributive justice, which is basically a fancy name for rationing. So in the first 2 principles, non-maleficence and beneficence, it kind of sets itself up as a doctrine of the double effect kind of idea. So as a doctor, I might do things to patients all the time that might be painful. So for example, vaccination. Okay, a vaccination hurts, or a needle hurts. That's the effect. But of course, and that effect arguably might seem to be maleficent. It's causing pain. It's not non-maleficent, so it hurts. But the set on the opposite of that would be beneficence. That I'm doing something that's painful for the sake of doing something that's better, which is to get you well. And so that kind of dichotomy is always present, really fundamentally in medical practice, that doctors sometimes have to do things that are difficult and painful for people because they appreciate that the final effect, the better effect, will be that they would get better.
So is that kind of like, for example, in a scenario where CPR is given, ribs are broken, that punctures someone's lungs, and they could die?
Well, I mean, sure that CPR. CPR stands for cardiopulmonary resuscitation. It's kind of a broad term.
But I mean, as it relates to the double effect.
Yeah. So you're certainly doing something that's painful to someone, but you're doing it because you're seeking a different effect, a better effect, a beneficial effect, recognizing there's going to be some pain in what you do.
On paragraph 19 of your report, it states the use of opioids to reduce pain and dying are justified under the bioethical concept known as the doctrine of double effect. How does that relate to palliative care specifically?
I think that palliative care specifically does not seek ever to end a person's life. It's a bright line that distinguishes between seeking death, which would be something like euthanasia, versus controlling symptoms. And palliative care, understands which side of the line it is on. It is not on the side of the line that would ever advocate doing something that specifically is intended to end someone's life. So palliative care is really all fundamentally about the control of unpleasant symptoms, around the time of dying, and that's really what it's concerned with primarily.
Okay. Now, when I want to talk a little bit about hastening death. Does removal of a terminal patient who is actively dying, does the removal of them from a ventilator hasten death?
Yes, it does.
Okay. Does the removal of vasopressors hasten death?
Yes, it can.
And so just overall, does the removal of any other life support measures hasten death?
Yes.
Okay. Next, I want to ask you about paralytics. How long is the duration of action in cisatracurium?
Cisatracurium.
Yes, that's the one.
All right. That's about 30 minutes when you give it, something like that.
Okay. And is that is that fairly established in the medical community?
In what capacity?
Is that pretty much what is taught through training, experience, and education?
In terms of how long the drug would last, you mean? Or cisatracurium is a drug that's, when injected, produces paralysis, temporary paralysis of muscles. It lasts about 30 minutes when you inject it.
And is it common to use that when intubating someone?
Sometimes when a person is intubated, that is, the breathing tube is placed in their mouth, that a paralytic, cisatracurium or others, can be used to create a better circumstance that would allow intubation, this placing of the tube in the mouth, to be conducted more easily. So it's a pretty standard kind of thing to use a paralytic as part of a sequence of drugs in order to intubate someone.
Now, I want to ask you about anoxic brain injury. When someone who has anoxic brain injury, do they still feel pain, suffering, and anxiety?
I mean, all of those things can very much occur even when someone has had an anoxic brain injury.
In your experience, when discussing that with patients and families, is anoxic brain injury an easy concept for them to understand?
I think that anoxic brain injury is an extremely kind of complicated idea. And it's so kind of counter to our own experience. And, you know, we experience our wakefulness, our alertness, our orientation, all of these kinds of things. Like, we experience them normally effortlessly. You know, we don't think about the act of being awake and conscious and oriented and so on. But, you know, many illnesses can push us away from that. An anoxic injury, and that's a word for a lack of oxygen to the brain, creates kind of a varied kind of picture. And the picture can be anything to where there's profound injury, where, you know, the brain just is absolutely, you know, fundamentally dysfunctional in any of the places that would normally create, you know, kind of who we are, where we are, our relationships, our capacity to learn, to know, to recognize people. All of that can be gone with an anoxic brain injury. Or it can be something milder. You know, it can be something that can result in confusion, disorientation, weakness. It's sort of a scale of things depending upon kind of the state of the person's health, how long they were anoxic for. I would add, too, that it doesn't take very long to get anoxic injury. So the brain needs oxygen constantly. And maybe as a corollary, think about how long you could hold your breath for comfortably. A minute and a half. That's about as long as the brain can hold its breath for, too. So after a minute or so of a lack of circulation, the brain starts to die. It starts to get injury. It happens very quickly.
Okay. Now, I want to ask you about tolerance, if I can briefly. How long does it take for a person to develop tolerance to opioids?
You know, tolerance is a situation where a person is given a drug and they have a certain dose, and then when re-exposed to that dose for the same symptom, it is no longer effective. So they need to give a higher dose. That's sort of the idea of tolerance. And for opioids, it can happen over, you know, if you're taking them regularly, over just a few days. After a few days of taking opioids regularly, you are developing tolerance to it, so it happens pretty quickly.
And can a person develop tolerance by taking opioids at home?
Absolutely. Absolutely.
And how is the doctor supposed to gauge that?
Well, you know, I mean, it depends, of course, on conversations and, you know, how it's being used and what the problem of pain is. Like, you know, the prescribing of opioids is ideally placed for people who have kind of acute, discrete pain. So that is that, you know, maybe an injury or something where they think the injury will heal, and then the need for pain control will gradually, naturally subside as the injury resolves. So when you're given, when you have chronic pain, which is can be not an uncommon and very difficult and challenging thing to treat, then you're, you know, filling opioid prescriptions month after month. And the problem is that if the underlying pain doesn't get any better, then the need for opioids will be escalating, you know, all the time. And it's tricky sometimes, you know, to know. Again, as I said before, there's no kind of blood test or machine that you can apply to a patient that says this patient has this much pain. You only have the history, the story that people tell you, you know, how they're using it and how much pain and pain control they're getting from it.
Okay. Can a person develop tolerance by using heroin?
I mean, heroin is an opioid, you know, like the others, and yes, people can use heroin and develop broadly opioid tolerance as a consequence that would then impact the amount of other kinds of opioids that might be needed.
What about carfentanil? What is carfentanil?
Yeah, so carfentanil is a synthetic opioid. And it's extremely potent. So it's 100 times as potent as fentanyl. And so it's actually specifically used for giving opioids or anesthetizing elephants. Okay? because an elephant is like, I don't know, 16,000 pounds. And so if you try to use, morphine or hydromorphone or even fentanyl, you need buckets of it. So it's super highly concentrated. It's so concentrated that, of course, it's extremely dangerous. So even a drop of it would kill you, potentially, if you're exposed to it, because it's so powerful an opioid in such a small quantity. In fact, it's weaponized, and can be used as a chemical agent.
I'll permit it.
So, it's a highly, highly potent synthetic opioid that's 100 times more potent than fentanyl.
We've heard a lot about elephants. They don't get a fair shake in this courtroom. So let me ask you this. How much does it take to put down an elephant?
Objection.
Sustained. You don't have enough foundation there for that one.
Are you familiar with how much carfentanil it would take to
Objection.
tranquilize an elephant?
Sustained. Lay a foundation.
That's all right. I'll move on.
No, we need to approach, Your Honor. I don't think he gets to say when we approach or not.
Well, I get to say whether you approach or not. The question withdrawn?
Yeah.
Ladies and gentlemen, disregard the question and the answer.
Now, Doctor, I'd like to ask you about acidosis. How does a pH level affect dosing?
So pH, I need to answer that by talking about pH.
Sure.
Hi, guys. Sorry it took a little longer, but I needed to stretch my legs a little bit, guys. Blame me. Okay? You got a request to go? Let's take 10 more minutes. That's not until when? Let her go. Guys, get her on out. Ladies and gentlemen in the audience, okay, there's been complaints about the noise level at times. You're not to talk while testimony's on, okay? Understand that's a direct order. If you get caught, you could be subject to contempt. Is that understood by everybody? And there's all kinds of nasty things I can do to you. The lawyers have been quieted. Now you are quieted, and it solves the problem. Okay? It's not being special to you. It's everybody now is that way. Anything for the record?
Nothing for me.
Okay, you guys have 10 minutes.
Thank you. Please be seated.
Okay, Doctor, you're still under oath. I hope you guys had a nice break, Mr. Baez.
Thank you, Your Honor. Dr. Zivitt, we left off on pH. Okay. What is pH in acidosis?
So pH is a scale, a number scale, and the numbers go from 1 to 14. And what the scale is it's a scale used in chemistry to compare two properties of certain kinds of chemicals. Certain kinds of chemicals are called acids, and other kinds of chemicals are called bases. These are maybe things you've heard of, some of these terms. Like, for example, people might know of acid reflux or something like that in the stomach. So, and these are, again, like it's a naturally occurring kind of property of chemicals, and this scale describes it. Now, in the scale, the number 7 represents something that is neither an acid nor a base. And at 7, we call that neutral. And the chemical that is neutral at 7 is actually water. So when you go above 7, it's considered to be a base. And below 7, it's considered to be an acid. And these things can be measured. Now, what's important about pH is although it's only numbers from 1 to 14, it uses a very specific kind of mathematical technique. And sorry, I know most people don't like to hear about math, so apologies in advance, but I hope I can explain this in a fairly straightforward way. So pH uses something called a log scale. And what is a log scale?
That's what I was going to ask.
Okay, well, instead of a number, when you go from 1 to 2, although you just go from 1 to 2, you're actually increasing the size of the number by a factor of 10. So 1 to 2 is 10 times, so 2 is actually 10 times bigger than 1. And 3 is actually 100 times bigger than 1, and so on. Now, why is it like that? Well, because you're actually talking about numbers that are really, really huge, okay? And it's hard for us to get around really big numbers. Now, I hope that this last example will make this clear. So there is actually a log scale that all of you might know, that maybe you didn't realize that's what it was. And that's something called the Richter Scale. And the Richter Scale is a scale used for earthquakes. Okay, now there may be earthquakes in Ohio, I think that there are. And sometimes you'll see flashed on the news, there's an earthquake, and maybe even you've been in an earthquake and you felt it. And so earthquakes might be, on the Richter scale, I think it goes up maybe to 10 or 9. Each number then represents a 10-fold increase in the strength of the earthquake. So to put this in perspective, if you have an earthquake that's on, say, 2 or 3 on the Richter scale, you might not even feel it. It might be very subtle. When you start to go up to 4, 5, 6, those are earthquakes that not only you feel, but they start to cause damage. Now, there was that very famous earthquake that caused that big...
We're getting a little far afield here. I sustained.
Okay, let me ask you this. What's the normal range for pH?
So the normal range for pH is between 7.35 and 7.45.
At what point does it become a very serious or dangerous thing? At what point does the acidosis become life-threatening?
Well, when the pH drops below 7, you're really in serious trouble. And I would honestly say that a pH anything less than 7.35 is already very abnormal. So I would be concerned about a pH of 7.3 or a pH of 7.2. So even though the number seems pretty close and pretty small, it actually represents, because it's a log scale, a very, very big difference. So someone whose pH is 7.2 has a lot of extra acid circulating in their bloodstream than someone with a pH of 7.35. And someone with a pH of less than 7 is life-threatening. That low, that degree of acid, is extremely abnormal in the body.
Why would a pH level be a dosing factor?
So the way that the body is designed is this acid-base thing has a very important impact on the way that chemical body systems work. So one of the ways that information is passed around the body is through proteins. For example, proteins are large molecules, and the way that these molecules work is they actually have a kind of a shape. So you may see pictures of these things, and of course they're always two-dimensional, but in the body they're three-dimensional structures. Now, if a certain kind of structure, they fit and work in a certain sort of way. And when the pH changes, the structure changes. So pHs will change the protein configuration, and when the protein changes its shape, it doesn't work anymore. And so the body starts to break down. So all these kind of chemical messengers are very much dependent on that very specific band of pH, and when you drop below, it all starts to fall apart.
Now, I want to turn focus to the 14 patients in this case. We've heard a lot about them, so don't worry, I'm not going to have you here for 2 days.
Okay.
But you had the opportunity to review all the records for all 14 patients, correct?
Yes.
And that included the dose amounts given during the palliative withdrawals, correct?
Yes.
Including the fentanyl, Versed, and Dilaudid as per their respective patients, correct?
Yes.
Now, in your report, you state that upon review of the medical facts, each of the 14 patients suffered a variety of severe and unrecoverable illnesses. After reviewing the records, do you stand by that statement?
Yes.
And does that pertain to Bonnie Austin, Joanne Belisari, Danny Millette, Rebecca Walls, Brandy McDonald, Beverly Schertzringer, Francis Burke, Melissa Penix, Ryan Hayes, James Allen, Troy Allison, James Timmons, Sandra Castle, and Jeremiah Hodge?
I'm going to take it on faith that those are all the names. I believe that those are all the names, so yes.
Okay. Now, you also state, in each case, recovery to a normal state of health was not possible. Do you stand by that statement?
Yes.
And that relates to all of the 14 patients that I just mentioned?
Yes.
Okay. And you also state in your report that the underlying illnesses that, let me use your exact words if I can, to a certain extent, to sum it up. You also state that the underlying medical state was the cause of death for these 14 patients. Does that apply to Bonnie Austin?
Yes.
Joanne Belisari?
Yes.
Danny Millette?
Yes.
Rebecca Walls?
Yes.
Randy McDonald?
Yes.
Beverly Schertzringer?
Yes.
Francis Burke?
Yes.
Melissa Penix?
Yes.
Ryan Hayes?
Yes.
James Allen?
Yes.
Troy Allison?
Yes.
James Timmons?
Yes.
Sandra Castle?
Yes.
And Jeremiah Hodge?
Yes.
And this is after reviewing their underlying medical condition as well as the dose that they were given at palliative extubation?
Yes.
I have no further questions. Thank you, Doctor.
Cross?
One second, Your Honor.
Good morning, or good afternoon, Dr. Zivit. Taylor Mick on behalf of the state of Ohio. How are you doing today?
Hi, Taylor.
Dr. Zivit, you've testified as an expert witness in other cases before, correct?
Yes.
Do you write your own reports in the cases?
Yes.
Do you update your own CV?
Yes.
Right. Doctor, have you testified as an expert in the case of the defendant is Zane Floyd out of Nevada?
Yes.
And showing you what is marked as State's Exhibit 59. Judge, do I need to do something to...
Should be up there. Says it's working. There we go.
Right. Showing you State's Exhibit 59. Is this your affidavit or report from the case of Zane Floyd?
It looks like it.
Does it say here at the top it's under penalty of perjury?
Yes, yes. Yes.
And then is that your signature at the end?
Yes.
Right. And is this your CV that was attached to this report?
It looks like it.
Turning your attention here to section number 9 under education. Do you actually have a bachelor's of science degree?
This version was mistaken. It was prepared actually, I guess, by an admin who made a mistake. So I submitted actually a subsequent CV in this case that corrected that. I don't have a Bachelor of Science degree. It's not required for entry to medical school in Canada.
Do you have a master's of science and from the University of Toronto?
No, I have a fellowship in anesthesiology. It doesn't say Masters of Science.
In section number 9?
Section number 9. No, that's incorrect. So I think that these things were made by my admin, which I did not see, and I've corrected them.
But I thought you just testified. Do you not prepare your own CVs and reports?
Well, I prepare my own CV, but I didn't see those things.
You didn't see that you put down that you have 2 degrees that you don't?
Those were mistakes, and I see them, but they weren't by me, or certainly not intended.
Would you agree with me that you didn't actually update that until you were cross-examined about that under oath?
I didn't notice it. It's a long document. It's like 26 pages or something, so I just missed that.
But it was a document you prepared?
Yes, it was.
Doctor, is it fair to say that you're a vocal advocate against lethal injection?
A vocal advocate against lethal injection. Can you tell me what you mean by that?
Have you published multiple articles against lethal injection?
I have concerns about lethal injection, and I've stated so, yes, publicly.
Have you done interviews about that?
I have.
Have you done international news interviews about that?
I have.
Have you testified as an expert multiple times on that topic?
I have.
Is it fair to say you are also, in the same term, using vocal advocate in that same way, a vocal advocate against what is known as doctor-assisted suicide or medical assistance in dying?
Yes, yes.
And the same question with regard to euthanasia in the context of euthanizing human beings?
Yes.
And you said you've written articles on these topics.
I have.
Have you also done a TED Talk on this topic?
I have.
Doctor, I want to show you what I've marked as State's Exhibit 60. Doctor, what I've marked as State's Exhibit 60 is an article titled Gorsuch Grapples with Death, A Physician's Viewpoint by Joel Zivit. Did you write this?
I did.
All right. At the top of this page, it reads, all human beings are intrinsically valuable, and the intentional taking of human life by private persons is always wrong. Is it correct you're quoting now Justice Gorsuch at this point?
Yes.
And then it continues here, private persons refers to physicians as it is generally uncontested that private citizens should not kill others in the normal course of events. Did you write that?
Yes.
It also then continues, doctors have the power to spin a convincing case for withdrawal of care when patients are ill, and the patient's families believe that the choice before them is the only one. It is important to recognize that so empowered, some physicians will act to end life. Did you write that?
This is in the context of euthanasia, though, is what I was referring to here.
But did you write this?
I wrote that, yes.
And down here, I don't know if Gorsuch approaches this as an intellectual exercise or his end-of-life view is drawn from first-hand experience. Regardless, he is absolutely right in the position he takes against physician-assisted suicide and euthanasia. If we permit our doctors to kill us, doctors can and will abuse this freedom. Did you write that?
That's what it says.
And this is actually, you're speaking in the context of physician-assisted suicide and euthanasia, not lethal injection, correct?
Correct.
I would now like to turn to State's Exhibit 61. Your Honor, can we approach, please?
Sure. Ladies and gentlemen.
Your Honor, may I approach?
You may.
Dr. Zivit, showing you State's Exhibit 61. Have you seen this article before?
No, I don't think so. I don't know.
Can you please turn to the second page?
Objection, Judge.
Okay, well, I'm going to give her a little leeway here, but you got to tie it in.
Okay, what am I,
For the record, he stated.
I heard what he said.
I'm sorry, you want me to read out this.
No, I don't want you to read it. I want you to look at the second page, and there's a quote there. Is that your quote?
I don't know. I can't recall.
Doctor, I'll turn to State's Exhibit 62.
Objection beyond the scope.
Let me see it. Is this some of the last one? I'll let you take it. I'm going to sustain the objection for now, but you need to lay a foundation. You can show it to him.
Dr. Exhibit, showing you State's
Okay, I told her I sustained your objection so far. I'm permitting her to approach the witness to see if she can lay the foundation.
Okay.
I treated everybody the same.
Understood.
Dr. Exhibit, showing you State's Exhibit 62. Are you familiar with this article?
I don't know. Not off the top of my head, but it doesn't mean that I haven't seen it in the past, but not currently.
He's objecting.
Yeah, we might as well.
Dr. Exhibit. Oh, sorry. Are we? There's an article on your CV titled "Anesthesia Does Not Reduce Suffering at the End of Life" by Joel B. Zivit, MD, FR, CPC from Emory University Hospital. laying the foundation. Is this?
Okay, hold on a second. Why don't you show it to him?
Doctor, did you write this?
What's the exhibit number?
63, I believe.
Okay.
Can I read this? Can I take a moment to read it?
Yeah. You need to do that in order to recognize it.
I recognize this, yes.
Did you author that?
Yes.
Just for the record, that was State's Exhibit 63. Actually, may I approach again?
Sure.
Now that you've reviewed this article, do you recognize State's Exhibit 62 as the
Objection, Judge, I don't know what she's showing.
the same thing I just showed him?
I don't think that actually refers to that.
Okay. She's asking the questions. You can't analyze what she's asking. Just answer them, please.
Doctor, if I can show you State's Exhibit 63 again and have you look at the references here of articles that you were citing.
Oh, I see. You're saying this is a site for this as opposed to this addresses that, which it doesn't. It's a different, this is, of course, addressing, paper by others. So that's just a reference for this. Yes. Okay. This is a long time ago, actually, too, so it's hard to remember it.
All right, Doctor, showing you State's Exhibit 63, the article that you just identified that you authored, titled "Anesthesia Does Not Reduce Suffering at the End of Life." You did write this letter to the editor,
I did.
and it starts that it is addressing an article, Billings, and then it's cited 1 with this reference 1. Is that correct?
Yes.
And in this article, it reads, "Anesthetic unconsciousness is not sleep. It is not restful nor natural." Did you write that?
Yes.
It also reads, "The suggestion that anesthesia reduces suffering at the end of life is speculation only." Did you write that?
Yes.
It continues, "What anesthesia does provide is the appearance of calm in the dying patient as witnessed by the observer. To suggest otherwise is at best misinformed, at worst theatrical." Did you write that?
Yes.
May I approach, Your Honor?
May.
Alright, Doctor, showing you State's Exhibit 64, last rites assisted suicide is neither dignified nor painless by Joel Zivit. Did you write this?
Yes, I did. Right.
Doctor, showing you State's Exhibit 64. It reads, as a doctor and expert witness against the use of lethal injection for execution in America, however, I am quite certain that assisted suicide is not painless or peaceful or dignified. In fact, in the majority of cases, it is a very painful death. Did you write that?
I did. Of course, we're not talking about assisted suicide.
Slow down.
Here.
Doctor, you also wrote, advocates of assisted dying owe a duty to the public to be truthful about the details of killing and dying. People who want to die deserve to know that they may end up drowning, not just falling asleep. Did you write this?
I did.
Thank you. Doctor, is it also fair to say that you've been an outspoken critic of using medication to curate the experience of dying for the sake of people observing the individual's death at bedside?
You're specifically referring, I think, to the death rattle, so I understand your question. And if you're talking about that, then yes, I've commented on that.
Doctor, I want to show you State's Exhibit 70.
Can I see it?
Yes, sorry.
Beyond the scope and contrary to course written.
I'm sorry, and?
Contrary to course
Contrary
written.
Let me see. Okay. Go on the side. Mr. Baez, would you care to join us?
Doctor, are you familiar with the silence trials on the death rattle?
I believe so.
Isn't it true that you have actually criticized these trials?
If you're, yes, I believe that's, yes.
It's true that you criticized specifically the use of medication to silence the death rattle?
A specific medication.
Doctor, have you also said that the death rattle is not...
I haven't heard the rest of the question. Go ahead.
Have you also said that the death rattle is not believed in the common medical assumption to be painful?
I think it's unclear is the problem.
No, her question is, did you say that?
You'll have to show me where, I don't know.
You don't remember whether you said it or not?
I don't know. If you're quoting me, then you could show me the quote.
Your Honor, may I refresh his recollection?
Well, you haven't asked the question.
Is there something I could show you to refresh your recollection?
That it's written that I said that.
We have no objection.
Okay.
And identifying it, this is State's Exhibit 70. Directing your attention to this second paragraph.
So, I'm sorry, ask me your question again.
Have you written that it is the common medical assumption that the death rattle is not distressing to the patient?
The common medical assumption, though, maybe I could actually back up.
Your Honors.
Well, I can't answer
Hold
your
on,
question.
don't read out loud. Read the thing and then answer her question.
I can't answer with a yes or no exactly the way you're asking it.
Okay, then you can't answer it yes or no.
I can't answer it yes or no.
So, Doctor, just to clarify, you cannot answer with a yes or no whether you have written that the
Objection has to answer.
I'm clarifying
Well,
what.
he's repeating, okay?
I want to clarify what he can't answer yes or no.
He said that he refreshed his memory and he couldn't answer yes or no whether that refreshed his memory.
As to whether
So
he
you
wrote.
have to take that as a no. Well,
I think he said he can't answer it with a yes or a no, not that it didn't refresh his recollection.
okay. Did it refresh your recollection reading that?
I see that, but I can't answer it yes or no.
Well, the question is a yes or no question. It's not an in between. Did that refresh your memory?
Well, if the question is, did it refresh my memory? Yes, it refreshed my memory.
All right, now that your memory has been refreshed, have you written that the common medical assumption is that individuals are not distressed by the death rattle?
Objection has to answer.
Wow, overruled.
I think that in order to understand that, I would have to give some more context to that paragraph, or that sentence that you excerpt. I think on its own, it may be misunderstood what I meant.
I'll move on from that, Doctor. Doctor, just to actually, before I move on, you've also done podcasts on the topic of the death rattle, correct?
Correct.
And in those podcasts, would you have discussed the common medical assumption?
Podcast, I think
Podcast.
singular. I don't know. I can't recall.
State's Exhibit 65, written by him. Doctor, do you recall writing an article titled When Patient and Doctor Disagree?
Can I see?
Okay, so you would need it to refresh your memory?
Yes.
Showing him State's Exhibit 65.
This is a letter, is what it is. And this.
Sorry, did you author that letter?
Look at this. Yes.
Thank you. Doctor, showing you State's Exhibit 65, when patient and doctor disagree, which you have authored. This reads, which week a patient arrives in the ICU might mean the difference between life and death. Doctors spin powerfully, and patients and families believe that the choice before them is the only one. That's what you wrote, correct?
Because that was what the study said,
This is what you wrote, correct?
in reference to the study.
Okay. So you did write this.
In reference to the study.
Thank you.
Yeah.
When you're talking that doctors have biases that may impact their decisions and their discussions with family, do you still agree with that statement?
I think that doctors are people and they can have biases, yes.
And you, as you indicated, I believe that you have read studies that support that conclusion.
Yes, the doctors have been known to have biases. That's well known.
And Doctor, you actually teach medical students and residents and things like that, correct?
I do.
Do you teach them about the discussion that they need to have with families at the end of life?
Yes.
You actually talked about that in your TED Talk as well, correct?
I believe so.
Am I correct in thinking that you probably take pride in education and teaching the next generation of doctors?
Take pride, yes, sure.
And you would find it to be an important part of your job?
To what?
Do you find it to be an important part of your job?
To be a teacher?
Yes.
Yes.
Am I correct in thinking that when you teach these students and future doctors, you're trying to teach them best practices for the end-of-life discussions with families, correct?
Yes.
Hypothetically, doctor, if you were teaching one of these future doctors and they said something in an end-of-life talk that you didn't agree with or feel was appropriate, would you try to help them improve for the next time?
I think you need to, that's a very broad question. So I guess I could answer it very broadly, which would be, perhaps depending upon, but I'd have to know exactly more specifically what you were talking about and how I might address that.
I can ask you some specifics then.
I'm going to object. This is all beyond scope.
That's a rule.
Doctor, would it be acceptable to you for one of the doctors you are training to not present the family with all of the options available to them for end-of-life care?
I don't know what you mean by that exactly.
For example, if...
Okay, well, you need to rephrase the question. You didn't get your question.
I'm going to rephrase right here. To explain, doctor, are you familiar with the status of being full code?
Yes.
Are you familiar with a DNR-CC order?
Yes.
Are you familiar with a DNR-CCA?
Yes.
So hypothetically, if a doctor you were training approached a family at the end of life and they told them the options were full code or DNR-CC and they didn't present the option of DNR-CCA, would you find that problematic?
I would have to hear the whole conversation to know. I would need to know the whole conversation.
Do you find you're big into ethics, correct?
Big into ethics.
Do you find the concept of informed consent to be important?
I think informed consent is an important concept, yes.
What does informed consent mean to you in that context?
It means that to the best of our ability, we provide patients with all the necessary information that they are able to manage and that they desire in order for them to make the best and most informed choice that would reflect their own particular wishes and desires.
When you say that you need to provide them with all of the necessary information, would you find providing them with the 3 code status options to be necessary information before asking them to make a decision?
It depends on what kind of conversations had taken place already and what they were saying. Sometimes people want some information and sometimes they want other information. It's dynamic and situational.
In what situation would it be appropriate for a doctor to not present a family with all of the options?
Well, you need to clarify what you mean when you say all of the options.
And
and I think you're talking about broadly whether or not they want to proceed or whether they don't want to proceed, right? Is that what we're talking about?
No, Your Honor, or sorry, not Your Honor. Dr. Zivit, I'm talking about all of the options as in, hypothetically, a patient is unresponsive. They can no longer make decisions for themselves. The family member that is the proxy, the power of attorney, has to make the decision now on behalf of that patient. There's no advance directive. Would you find it appropriate to not present that power of attorney with all of the options that they could make on behalf of that patient?
Well, there are basically 2 options. One option is to proceed and with all kinds of care, and maybe that would be the direction towards palliative care. So those are the options, and I believe that in these cases that was the discussion that was taking place.
Dr. Zivit, you are aware that there is an option for a DNR CCA and a DNR CC as codes, correct?
I'm aware that these are the kinds of designations that are present in this particular hospital.
So would it be appropriate to not present those options?
I would have to hear the whole...
Objection has an answer.
I'll permit the question.
I would have to hear the whole conversation. Like these things, if you say to people, you can have DNR CC or DNR CCA, I think most people don't know what that means. So what you're really talking about, if you're saying by not saying, I said DNR CCA, therefore I didn't discuss it, I would have no way of knowing whether that was true or not true.
Doctor, I'm not asking you whether something is true or not true. I'm asking hypothetically, for a doctor to get informed consent, does he need to provide the family with all 3 options, what they mean, and let them make the choice between the 3 options?
Maybe you can tell me what the 3 options mean, and then I can answer your question.
Again, the 3 options are to be full code, to be DNR CCA, or to be DNR CC.
Well, I think that that is something that can be described in language and broadly, and so I think that that's my view on it. That you should inform patients, or in this case the proxy, of all those sorts of things, and to the best of their ability, they can then take that and decide what they want to do.
So to clarify, finally, you are agreeing that you should.
Sustain.
Doctor, showing you states 71. Doctor, you were on the ASA Committee for Ethics, correct?
I was.
You authored a chapter in the syllabus on ethics, correct?
I did.
Showing you states Exhibit 71. Is this that syllabus on ethics?
Could be.
I can approach if you'd like to take a closer look.
Okay. Okay, I see this.
And is this the syllabus on ethics that you authored a chapter in?
I believe so.
Well, did you see your name as an author on this paper?
I see a piece of paper with my name on it, so I'll take it at face value that it is that document.
Now showing you State's Exhibit 71. In this chapter that you wrote for, well, winding back, what is the purpose of the syllabus on ethics?
It's to provide information for practicing physicians on the subjects that are contained within the syllabus.
Is it sort of like a guideline on ethics?
It's information for people to use. Yes, I guess it's a guideline.
Okay. In this, did you write, it reads, the loss of decisional capacity is an extremely significant event for a person, and it is the responsibility of the proxy and the healthcare team to protect the interests of the person in question.
Yes.
Did you also write, physicians need to understand that they bring bias to every conversation and can spin information resulting in a proxy making very different decisions. No real discussion can take place unless all assembled are apprised of all of the relevant facts offered freely with neutral language.
Yes.
Did you also write, physicians need to acknowledge that they bring personal biases to the conversations and that these are so powerful to the degree that they might cause the physician to coerce rather than to inform a patient. Did you write that?
I did.
Did you also follow up and write, a strong bond among physician, patient, and proxy based on an honest, unbiased understanding of uncertainties and the facts allows the best opportunity for generating a healthcare plan most meaningful to the patient?
Yes.
And Doctor, would you agree it's important to follow these guidelines?
Well, I wrote them, so I guess I think it's pretty good.
Okay. And you would hope that other doctors would follow them as well?
Sometimes doctors do whatever they want to do. What can I say?
Doctor, going back to hypotheticals, let's say one of the doctors that you were training, they told a family in a proxy that their loved one was brain dead during this end-of-life talk, but no testing had been done to confirm whether this patient was actually brain dead. Would you find that to follow your teachings?
So are you saying that if a training doctor who probably shouldn't be having these conversations unmonitored anyway, so we're talking about something that would really not take place, because training doctors would not be put in charge of these sorts of conversations if they were, depending upon where they were in their training.
I can rephrase then.
Okay.
All right, hypothetically, if a doctor approached a family and told them that their loved one was brain dead during an end-of-life talk, but no testing had been done to confirm whether the individual was brain dead, would you find that to be true informed consent?
I think I would need to know why the doctor, if the doctor said that a person was brain dead, I guess I would need to know why they said that. So, testing for brain death is a confirmation test. So it's possible that a single doctor, upon examination, could really determine it. But the policy requires two physicians and some other factors, but a single physician certainly could have enough information to believe that the patient was in fact brain dead.
When you say a single doctor, are you referring to a neurologist?
No, not only a neurologist, other doctors too. I can declare people brain dead as well. I'm qualified to do that.
And why does that policy require two physicians to make that determination?
It's just a level of certainty, because if someone is brain dead, it means that they're dead.
So if someone is brain dead, does that mean that you can then ethically give them any dose of fentanyl that you want because they're dead?
No, if someone is dead, you don't need to give them any fentanyl because they're dead.
So if an individual is brain dead, you don't need to give them any fentanyl?
If a person is brain dead, you need to bury them. That's what you need to do.
If a person is brain dead and still on life support, and the family makes the decision to withdraw?
If a person is brain dead, they are dead. So whether or not a family chooses or not to choose, now there is some controversy around this, but I think the controversy is incorrect. A person that is brain dead is dead, and therefore they cease to have rights of the living. They are now dead, and so that's how they should be treated.
Okay, doctor, then under your view there, if you were treating a patient that was brain dead and family was withdrawing life support, would you give them fentanyl?
A person that is dead requires nothing. A person that is dead requires, because they are dead, they are no longer a person. And so as a non-person, they have a different set of rights and privileges than they would as a person. So there's no reason to give a dead person anything.
And
Former person.
when you're referring to them as former people, they still have a heartbeat, correct?
That doesn't mean that they're dead. Brain dead means dead. So they can have a heartbeat, but they're dead. That's what brain death means.
Then why can a family choose to keep a brain dead individual on life support if they're a human that has, or former human that has no rights?
I would have to ask the law about that, because in certain jurisdictions, that's permitted for, I think, wrong reasons, and in other jurisdictions, it's not permitted.
Have you ever known someone that had a severe anoxic brain injury to recover?
Recover. I don't know what you mean when you say recover. To what state? To be completely recovered so they have no residual effects of the injury?
No, to wake up and be removed from life support.
And then what?
That's recovery. They've woken up and been removed from life support and continued to live.
I think I've said that anoxic brain injury can take different forms. So some people have anoxic injury and they might be able to be on a ventilator, for example, and they might be in some kind of state of unresponsiveness or diminished responsiveness. So if that's what you mean by recovery, then some people with anoxic injury can end up like that, yes.
Some people can end up waking up.
Well, I don't know that it's waking up exactly. It's not really, first of all, they're not really asleep when they have anoxic injury. And so when they become, they can have they can exhibit signs that can be quite distressing to people. For example, their eyes may be open and they may even look around, but they have no, it's clear that they have no understanding of what's around them, or not some easily measurable way. So you can be in their line of vision and you can call their name and there's no response. So open eyes, can occur in a setting of anoxic brain injury, but it doesn't mean that they're functional in any meaningful way.
Can a person that had an anoxic brain injury and was on a ventilator recover to the point that you just said, functional in a meaningful way?
Well, I guess we're going to have to talk about meaningful. What do you mean when you say meaningful?
I was using your words, doctor. What did you mean?
I mean, I think that, most people would, meaningful recovery, I think, would be an ability to know people, to know who they are, to be able to interact, to manage their own affairs, maybe to walk under their own power, to not need a ventilator. So those are all the kinds of things that I think are meaningful recovery. And anoxic injury, is a serious injury. It can be gradations. So some people might be, when recovering from an anoxic injury, or may get to a state where they can be open eyes and on a ventilator, or even be extubated. But anoxic brain injury people generally are institutionalized. They need lots of round-the-clock care, and they can't take care of themselves, and they don't know who they are, and they don't know who you are, and that's anoxic brain injury.
Their family members could choose to bring them home and take care of them, though.
They could.
Okay. And doctor, just for clarification on this spectrum you've created of former person to person.
That's not my spectrum. That's what it is.
Okay. On that spectrum, where do you put a person that is technically has a heartbeat and is awaiting to see if they can have their organs donated?
Well, the only person that can actually donate an organ, a solid organ, so we're not talking about a kidney, I assume, we're talking about a heart or lungs or liver that would cause the death of a person if they were alive. We can't take organs from a living person. They can only be taken from dead people. Like brain dead is the reason why we have brain death is for the very reason that I think that you suggest, which is the removal of solid organs for the purposes of transplantation. There's something called the dead donor rule. We can't take organs from people that are alive. We can only take them from people that are dead.
So hypothetically, if a person was waiting to see if their organs were suitable to be...
This is all beyond the scope.
It's cross-examination. Hypothetically, if an individual was waiting to see, they were brain dead, as you've said, And
Sorry, I don't know what you mean, waiting to see if they're brain dead?
No,
Waiting to
sorry.
see if they're,
I'm rephrasing. Strike that. If they are brain dead,
yes.
do you have to run certain tests, or how do you determine if their organs are viable to be donated?
Well, I mean, first of all, there would have to be a consent that would be obtained from the family or the patient in advance to say that they were willing to be an organ donor. And then, once they're dead, it's actually handled in a very specific sort of way. So there is an organization called UNOS, United Network Organ Sharing, whose job it is to come over and manage now the body. Okay? So now it's a body that's being there maintained with circulation for the purposes of harvesting organs. That's no longer a living person. And once a person is declared brain dead in the ICU and there's conversation about organ donation, I, as the ICU doctor, have nothing more to do with that former person. That's now UNOS's job to manage that. I have nothing to do there with that.
Okay, what, hypothetically, if UNOS did all that and they determined that this individual was not suitable to donate their organs, is that passed back to you then, as the individual is in your ICU?
No, they're already dead. So then they go, they go to the morgue.
So they're in your ICU on life support, UNOS rejects them, you don't do anything?
It's just, I think they're just removed, they're removed and then they're taken. But remember, you're using a term incorrectly here, which is life support. This is now death support, okay, because these people are dead. So what you're talking about is just keeping the organs circulating for the purposes of possible organ donation, but they're not a living person. They're dead.
And is that just your medical opinion that they're dead?
I don't know what you mean when you ask me that, my medical opinion. You mean, is that an opinion that they're dead?
When you're saying they are dead, is that a medical status that you're saying, or is that a legal status?
That's a legal status.
Everywhere.
Well, I believe it's everywhere. I mean, I think that there may be some, I don't know.
Now discussing the law.
Yes.
About the law.
Let's stop.
I'll move on. So then I guess, doctor, if someone, or you, we'll say someone hypothetically, was brain dead, and now they're a former person, they're dead, they've been rejected for donating their organs, they need to be withdrawn from death support. Hypothetically, if a doctor gave them large doses of medication in this situation, would the doctrine of double effect apply to that?
I don't know why someone would, I'm not following you. Why, this hypothetical, I don't know why anyone would give fentanyl to someone that is dead.
All right, thank you. That, I think, answers it well. Doctor.
Strike objection, we'll strike.
Basis?
Commentary, Judge.
Okay. As to your comment about it's sufficient, sustained.
It's fine.
Or the extent you said it was
All right.
sustained.
So, doctor, I guess back to the hypothetical. A doctor is telling an individual that their loved one is brain dead when this hasn't been confirmed as part of the end-of-life talk. Would you find that to be coercive, or would you find that to be informed consent?
I don't have any opinion about that.
You don't have an opinion?
I don't know. I would need to know much more of that. When you say coercive, that's a very specific kind of claim, so I don't know whether it's coercive or not coercive.
Wasn't coercive the word that you actually used in the syllabus on ethics?
Well, but we're talking about your hypothetical. So in your hypothetical, you've asked me, is it coercive for a doctor to, and maybe ask it to me again?
I guess we can take it a step back. When you write that a doctor can coerce rather than inform a patient's family, what do you mean by that?
That sometimes doctors may, in their conversation, represent a point of view. I think that, this I think you've seen in this case, that doctors have different points of views. So what the caution here is to be mindful of one's point of view and how one's point of view, is brought to bear in a conversation. That's just something that a normal, well-trained, well-practicing doctor does.
Would a normal, well-trained, well-practicing doctor tell a family that their loved one was brain dead when no such studies had been done to confirm that?
I don't know. I would have to know more about that conversation. Like if you're not talking about something in this case, right? You're just talking about a hypothetical, which has nothing to do with this case.
Judge, he's asking me a question.
Well, I'm not aware that anyone is brain dead in any of these patients. I didn't see anyone that was brain dead.
All right, well, hypothetically, if Dr. Husel had told some of these families that their loved one was brain dead,
Go ahead and ask the question.
what would your opinion be on that?
I don't, then it would be a different matter entirely. It wouldn't be this matter. It's not written anywhere that I saw that Dr. Husel said anything like that.
Hypothetically, if a family member of one of these victims...
Objection, Judge.
Sustained.
All right. So I guess it's not written in anywhere that you saw it. You would agree that things that occurred don't always make it into the medical records?
True.
And you've reviewed the medical records in this case, correct?
I have.
How much detail was there on Dr. Husel's end-of-life talks?
Well, I don't, when you say detail, I don't know what you mean. I think it was documented in some places that end-of-life talks took place.
And was there any description of what he said during those talks?
You'd have to show it to me to remind me. Doctor, I guess hypothetically, if someone had told 4 families that their individuals were brain dead without testing, would that...
Action, Judge.
Sustained. Maybe it's break time, guys, because I need a break.
We're here today to announce the results of an approximate 6-month investigation, a 25-count indictment against Dr. Husel for murder.
How did we get here?
Let me express my deepest condolences to the families.
You gotta be joking. It can't be. Why would he do that?
Here.
Okay.
A place where families are reliving pain.
We're all hurting.
Mm-hmm.
We're all horrified.
Here. A place where a doctor is accused of killing his own patients.
Dr. Husel, do you have any answers as to why?
No comment.
Is it fair that you're walking out of jail today?
No comment again. Sorry.
Do you have anything you can say to the dozens of families who are hurting right now?
Never did Dr. Husel or anyone on his team have the intent to speed up a patient's death.
So how did we get here? In this series, we will answer that question and others and explain to you how we broke the story of the patient overdose scandal at Mount Carmel. It is more than just the story of a lone doctor accused of giving his patients too much pain medication. It's much more than that. It's about a series of missteps, miscues, and miscalculations on the part of a health organization that helped contribute to a tragedy.
I was just wondering if you might have some time to talk with me.
So we called Dr. William Husel on January 14th. That's the same day we went on air with the story.
Have you already retained a lawyer, or is there someone I could call?
He declined to comment, telling me to contact his attorney. We had been working on this story for several days, acting on a vague tip that a doctor had been dismissed from the hospital. We were pushing our sources for more information, and we were able to get a hold of some internal memos from the hospital showing that the doctor had not lived up to the hospital's standards of care. The day we went on air with the story was the day that first lawsuit was filed. It was also the same day that Mount Carmel released a video statement.
Hello, I'm Ed Lamb, President and CEO at Mount Carmel Health System.
So Mount Carmel put out this video announcing that Dr. William Husel had been fired and that over 5 years he had ordered significantly excessive and potentially fatal doses of pain medication that had been given to 27 near-death patients. They all died. The hospital at the time also announced that it was suspending 23 nurses and pharmacists for their roles in administering these drugs.
On behalf of Mount Carmel and Trinity Health, our parent organization, we apologize for this tragedy, and we're truly sorry for the additional grief this may cause the families.
What we would later learn is that the hospital created a second video. This one was only sent out to staffers and, in part, laid blame.
Sadly, our investigation revealed that some of our colleagues did not meet our standard of care. The actions that created this tragedy were instigated by this physician and carried out by a small number of good people who made poor decisions. They ignored the safeguards we have in place.
So in that second video, Ed Lamb appears to lay some blame on the staffers, which is different from the video that was released to the public.
We take responsibility for the fact that the processes in place were not sufficient to prevent these actions from happening.
What we would later learn is that the hospital had been investigating for months, and that when it first learned of an allegation involving Dr. Husel's patient care, in between the time they learned that and when they removed him, 3 more patients died, something we would attempt to press the hospital on later.
Was there any chance to remove him
Not
prior to
before
that?
October, no.
No upper level management knew prior to that?
No.
He shortened her life. He took her right to choose her death away. And I just feel that Mount Carmel should have stopped him long before this happened.
Albert Belisari's sister Joanne was a companion nun, very active in her church. Of all the patients identified by the hospital as being tied to the overdose scandal, Joanne Belisari was among the first. She died in 2015 and was the first to receive 1,000 micrograms of fentanyl.
It looks and appears to me you had a rogue doctor, you had a breakdown in protocols in the hospital.
Albert says he feels let down that a Catholic hospital would allow something like this to happen.
They're saying it's comfort, but when Joanne, she was out of the comfort zone. She was going to die anyway. And he didn't even consult the family before he inserted the fentanyl.
That process in particular, Albert says, about the drugs being inserted, he claims was not explained to him.
I'm angry, we may have consented if he asked, but he didn't. He just chose it himself.
Another patient, Jan Thomas, died 2 months before Joanne in March of 2015. She got 800 micrograms of fentanyl.
Okay.
Reliving the loss of a loved one has been...
It just rips the wound right open again. So it hurts a little bit more this time.
The patient's families hired attorneys who sued Mount Carmel and Dr. Husel in wrongful death lawsuits. They claimed the doses were grossly inappropriate and that the hospital was negligent. Husel's attorney and those for the hospital have argued in court filings that these patients were in very poor health, or in some cases dying.
If his intent was not to cause them death, his intent was then to do what? What was his
comfort care? Comfort care. I think it's important that everyone watching this understand that the patients that we're talking about are end-of-life patients. These people were being kept alive primarily due to the equipment in the hospital.
Prosecutor Ron O'Brien used an analogy to sum things up. He said Husel's actions were akin to blowing out a candle while there's still some wax left over. A grand jury indicted Husel on 25 counts of murder because 25 patients, according to O'Brien, received 500 micrograms of fentanyl or more.
And I have found no one, nowhere, that says 500 micrograms of fentanyl is an appropriate use of fentanyl for treatment of someone being taken off a ventilator.
All of the patients were in Mount Carmel's intensive care unit, where Husel worked the overnight shift. Many families told us their loved ones were in bad shape, but they were convinced by Husel or others that their loved ones were dying or brain dead. Records show nearly all the patients got the drugs around the time their ventilators were being removed.
You know, you want to believe it's just a bad dream and that it's not true.
Lisa Coleman recalled a conversation she had with Dr. Husel about her father, Jim Allen.
He said, I can promise you that he will not suffer and he'll go quickly.
Did they tell you that Jim was brain dead?
They said he was in complete organ failure.
That's what they told us.
That's basically what they told us too. Yeah.
After news of the scandal broke, the Centers for Medicare and Medicaid Services steps in, sending state health inspectors to the hospital to find out what went wrong. They find in 24 of the 27 patient cases they reviewed that Dr. Husel used an override function on a medication dispensing machine to essentially bypass the pharmacy and gain access to pain medications like fentanyl. To the families and their attorneys, this is the hospital's internal safeguards were not working.
This proves their negligence. That they weren't guarding, watching the ship. The records should speak for themselves.
The hospital says it first learned of an allegation involving Husel's patient care through a formal report that it received around October 25th, 2018. But it didn't remove Husel from patient care until November 21st. And during that period, the hospital got additional reports, and 3 patients died.
We want to know what that formal report was. We want to know what informal reports they had. Reality would tell us that somebody in this 4-year period of time was saying something about this.
Was the hospital aware before October?
We've been discovering things all along as we've been learning through the investigation process.
But was there any chance to remove him prior to that?
Not before October, no.
It's only after these lawsuits are filed and CMS steps in that we learn from Mount Carmel that some of the patients could have seen their conditions improve with other treatment. And we start to hear from sources inside the hospital this tragedy could have.
Hello, I'm Ed Lamb, President and CEO at Mount Carmel Health System.
The same week the news broke about the patient overdose scandal at Mount Carmel, the federal hospital find out exactly what went wrong. How did these large doses of medication end up in the patients? By late February, the hospital admits that some of these patients could have seen their conditions improve.
We are aware of 5 cases in which this possibility is a concern.
All this time, we had been talking to Mount Carmel employees, some of them telling us key details. None wanted to be identified.
It is absolutely.
I did speak to one who worked directly with Dr. Husel.
He is well respected among the staff members.
Source says the allegations against Husel that he allegedly accelerated the deaths of 35 patients could be hard to prove.
The line between providing comfort and accelerating death is a very great one.
His criticism was aimed at the hospital, who he says erred in suspending nurses and pharmacists who helped administer or approve these drugs, saying they hadn't been trained properly in all the facets of ventilator removal and that the hospital's internal safeguards weren't strong enough. Husel's accused of ordering large doses of fentanyl and using that override function on a medication dispensing machine to bypass the pharmacy and gain access to the drugs.
So in other words, you could order, you wouldn't have to tell the pharmacy you were doing a ventilator withdrawal?
That's exactly right.
You could just say, I need 1,000 micrograms of fentanyl.
That is exactly right.
So the source says that Husel was very much liked by his colleagues and that he even helped train some of the people working in the ICU.
Did anyone challenge Dr. Husel over these high doses?
Now, Dr. Husel has been known to prescribe high doses of narcotics and sedatives. He has been challenged, and there have been verbal communications to managers about these things, but no one expected that these events had led to death.
Mount Carmel has said it did not learn of concerns about Husel's patient care until October of 2018, when it first began to investigate. But sources tell us that the hospital erred long before this, in 2013, when it first hired Husel.
The families need to know that, we could have prevented him from having those privileges and being on that floor, on that unit.
This source alleges that Dr. Husel didn't meet Mount Carmel's own criteria to work as a critical care intensivist. We got a copy of Mount Carmel's application for clinical privileges, and in order to work in the ICU, you have to either be a DO or an MD, have completed a fellowship.
Doctor, I just want to clarify, in creating your report in this matter, did you speak to any of the alleged victims' family members?
No.
All right. And Doctor, do you recall stating, I have certainly never given narcotics and thought, this is going to take away the pain of dying. It's not like anyone thinks this makes it less painful per se to die. It's unmeasurable and unknowable.
I don't know what that quote is from.
Is there something I can
I don't have any, I don't know.
Is there something I can show you to refresh your recollection?
I don't know.
Okay. Is that your answer?
Well, I don't know if there's something you can show me. Is there something you, yes?
There was some writing that may have reflected that. Might that refresh your memory?
Yes.
Right. Showing the doctor, States Exhibit 66.
Well, I mean, this is in the, I think this is in the context of the death penalty. That's all. That statement.
Did this refresh your recollection?
Does that refresh your memory on whether you made that statement?
I see it's there in quotations. Yes.
So you agree that you made this
Judge, we
statement?
would object and move to strike based on his answer.
Well, he said yes, so you're objecting to the word yes?
No, that it's in reference to the death penalty.
May I clarify this? Because I don't believe he's given any.
Are on competitive ground here right now. I suspect they're not considered punishment.
Respectfully, I don't think he's ever administered the death penalty to anyone. So if he's talking about medication he's given, that's not on the death penalty.
Compound or situation. Ladies and gentlemen of the jury,
Sorry.
any concept of death penalty is not permitted for you to consider. We've been through this with counsel, and anything that involves the comment death penalty, you're disregarding. Now you can see what you can do with it.
Thank you. So, doctor, you do recall stating, I have certainly never given narcotics and thought this is going to take away the pain of dying. It's not like anyone thinks this makes it less painful per se to die.
Objection.
In the context of the death penalty.
Okay. Doc, did you hear what I said? So you're saying that the only way that you hold that opinion
Is in the context of the death penalty.
So in your medical practice, you don't hold that opinion?
That fentanyl takes away the pain of dying?
Yeah.
I don't know. I think we try, but I can't be certain.
Doctor, if you say I certainly have never given narcotics and thought, have you ever given narcotics outside of the medical setting?
No.
Thank you. Doctor, you said that you were an expert in the matter of Zane Floyd in Nevada, is that correct?
Yes.
You were deposed in that matter, correct?
Yes.
And you also testified at an evidentiary hearing, is that correct?
I don't know the names of all of these things, if that's...
Did you testify in court before the judge?
I did.
All right.
Judge, I'm going to object. This is a case. This is a death
Okay, stop.
May we approach, Your Honor?
You may.
Well done, this guy. Doctor, sorry. Doctor, can you describe what chest wall rigidity is?
Chest wall rigidity is something that can occur in certain patients.
Objection beyond the scope.
I'm sorry? 611C, overruled.
May he finish his answer?
It's a stiffness that occurs in the muscles, primarily in the chest, that can sometimes occur in the setting of being given large doses of opioids.
And what do you mean by large doses?
Well, it's actually pretty variable. So I think that where chest wall rigidity was really, I think, commonly seen was in the circumstance of cardiac anesthesia, something which I have done. And in that circumstance, we were giving patients 100 mics per kilo of fentanyl. So a 70-kilogram person would be giving them 7,000 mics in a push. And when you give 7,000 mics in a push, certain patients kind of develop this sort of stiffness in their chest, you're helping them with breathing. You need to help them with breathing.
You've previously testified that you've also seen this phenomenon in COVID patients that you've treated?
I think so. I think so.
And were those COVID patients being given 7,000 mics of fentanyl?
They were on continuous infusion, so they had received thousands of mics of fentanyl.
You previously stated, I think rigidity can create the situation where one can experience this, unexpected and terrifying experience of not being able to take a deep breath, correct?
Well, again, that was in the context of the death penalty. Okay, well then, yes.
You previously testified when you were using opioids in cardiac surgery, you saw this virtually all the time.
I saw it commonly.
You've previously described this as feeling like a heavy weight placed on the chest of a patient that prevents them from breathing. Is that correct?
I don't know if that's I can't recall if I used those words exactly.
Moving on to actual dosing, doctor, I noticed on direct you, when discussing dosing, you use terms like a good amount or a little. I didn't hear any specific numbers. So I want to go through some statements with you. Do you recall previously saying that you would never, there's no clinical situation where I'd be giving 2,500 mics of fentanyl to somebody who wasn't either intubated or going to be intubated because I would be concerned with the dose that there would be some respiratory effects. Is that correct?
Well, can you remind me where I said that?
So you don't remember saying it?
I have to be reminded as to where it was that it was being said.
If I showed you your previous testimony, would that refresh your recollection?
So it was in the testimony is what you're saying?
Yes.
Okay, I can look.
I think there might be an objection based on them both standing up behind me.
Yes, Judge.
is a death penalty case that they're talking about. So I'm going to permit the testimony that you can't consider the concept of punishment. It's just for your context on where it's coming from. Okay? Any objection?
Will the witness be able to elaborate?
As long as it's in the context of explaining where it came from, fine. If it alludes to a penalty, no. So his answer when he said yes, but that wasn't a death penalty case, is acceptable. Okay? It is not to be considered for punishment purpose, but the mechanism that we're dealing with. Okay? Don't give it any special thing because it's a death case. It's just the context of where this came from. Anything else? Before I go any further, any objections?
No, Your Honor, thank you.
There's something else?
No, I was standing when I was addressing.
Oh, I thought you accidentally stood accidentally. Yeah. Ms. Nick?
Thank you, Your Honor.
And now, that wasn't the question. Any objection to my charge?
No.
Okay, continue on.
Doctor, yes or no? In a previous testimony, you were asked about a hypothetical and asked to assume that 2,500 micrograms of fentanyl were given, and you responded, well, you know, the only time I would do such a thing would be in the circumstances of an operation. Did you say that? Yes or no?
In the context of this death penalty case, yes.
Why would that?
I'm sorry, if maybe I misunderstood what your direction. If I misunderstood your instruction, I apologize.
Just to clarify, the only time you've given fentanyl is in...
This has been asked and answered.
Okay, I haven't heard the whole question yet.
or in clinical hospital settings.
I missed the beginning of your question.
The only time that you have given fentanyl, observed the effects of fentanyl, anything like that, is in a hospital setting.
Correct.
Thank you. Do you recall that you were asked if a person that was breathing just regular room air, oxygen with no support, if they were given 2,500 micrograms of fentanyl, if that would cause them to die? And you responded, I mean, you know, that's certainly one of the possibilities, yes? Yes or no?
I don't know what this is from.
If I showed you your previous testimony, would this refresh your recollection as to whether you said this?
I mean, can I answer? I'm assuming it's from the same thing that you asked, so it's from the death penalty case that you're asking me.
Mm-hmm.
So yes.
Do you recall being asked a hypothetical that if an individual was given 2,500 micrograms of fentanyl, that you would expect to see some respiratory depression or hypoxia to set in within 5 minutes, and you answered, I would expect that would be one of the things I might see. Yes or no? Did you say that?
I mean, can I read it? Like, I don't know whether you're. Can you show it to me that I can read my words?
Your Honor, may I let the witness read his words?
You want to approach him and show him what he said?
Sure.
So you're asking me, did I say I would expect that would be one of the things I might see?
Yes.
I see that that's highlighted, yes.
So you said that.
There it is.
Was that a yes?
Yes.
Doctor, do you recall testifying, or you previously testified, if a person was dying, say in the consequence of illness in the hospital, and I didn't think that they were having any pain, then I wouldn't give them anything. So I wouldn't give them something to where I'm seeking to kill them. They have to show me they're having some pain. So if they're not having, in fact, this is a conversation I have with families all the time. And I say, let's be clear. The purpose of fentanyl in this case is to treat pain. But if we don't see pain, I'm not reaching for fentanyl. I'm just not going to give that.
Yes.
Did you say that?
Yes.
Do you agree that you also said giving fentanyl to someone who isn't in pain doesn't make sense to me?
I would need to see what that was from.
Your Honor, may I approach? We'll mark this whole transcript as State's Exhibit 55. Page 184.
There's two things that are highlighted here. I'm not sure. Do you want me to read the highlighted part, or?
You can read it out, not out loud, but to yourself.
Okay, all right, I read that, okay.
So, Doctor, do you agree that you said giving fentanyl to someone who is not in pain doesn't make sense to you?
In the context of that case, yes.
This was part of your previous statement I just asked you about when you were talking about in the hospital setting you wouldn't give fentanyl to someone that's not in pain. Is that correct? Is that correct? Okay. When you're saying Doctor, you were under oath when you testified in this case, is that correct?
This case?
Yes. Okay. Do you recall, again, in the same case, you were asked if fentanyl is a good thing to use for palliative care at the end of life, and you answered with, and I quote, "If I intend to kill them with the opioid, then that would be murder, and I would not do that." You said that, correct?
Well, if I intended to kill someone, I'm sorry, read my quote again.
If I intend to kill them with the opioid, then that would be murder, and I would not do that.
Yeah, if I intended to kill someone, then that would be murder, so I would not do that.
Do you recall in that same case that you testified that if an individual did not have any pain, that 100 micrograms of fentanyl would be a sufficient dose to reach this?
This is all in the proper form.
Did you want me to finish, or?
I finished the question so I
Can you read back where I was, Sam? Sorry. Or I can just re-ask. I'll just re-ask it. In that same case, you testified that if an individual had no pain at all, 100 micrograms of fentanyl would be sufficient dose to reach the ceiling effect for pain relief. Is that correct?
I would have to know what was happening before to understand what I was saying there. I think it needs explanation. That's my concern.
Are you disputing that you said that?
No, I'm just asking if I can clarify that.
Specifically for context, you were being asked about the...
Objection in proper form.
I was going to ask a question after I... If you were being asked about the ceiling effect for pain relief when you're dosing fentanyl in a clinical setting, did you testify that 100 micrograms of fentanyl would be a sufficient dose to reach that ceiling effect?
If a person is having no pain at all, I would not be sure why I would be giving them fentanyl if they had no pain. So I don't understand. I'm not following what you're asking me.
Do you recall, or you also testified, for some people, a small amount of opioid goes a long way. Is that correct?
for some people, a small amount of opioid goes a long way.
And what is a small amount of opioid in that context?
Well, for some people, I mean, I think for what person or what context? Because a person, who is, say, who is maybe slight of stature, who is in good health, has never taken any opioids, is not having any pain. If they were given an opioid, a small amount of opioid, they may feel it.
Do you recall, or you previously testified about hypoxia? If hypoxia is left unchecked and severe, then it may eventually cause, the heart to beat irregularly and then cause a heart attack or something like that. Is that correct?
Is this in the Zane Floyd case?
Yes.
So, if you're asking me if hypoxia will have a negative effect on the heart, the answer is yes.
And what exactly is hypoxia?
Low oxygen.
And is low oxygen and hypoxia one of the potential side effects of fentanyl?
Well, yes, it can be.
All right. In the same case, when you were asked to describe the circumstances in which 2,000 micrograms of fentanyl could be fatal, you answered, to someone who is frail, someone who is critically ill, someone who is opioid naive. Those are the kinds of people that might, with a dose of that degree, might be the most at risk for death. You said that, correct?
This is in the Zane Floyd case.
Mm-hmm.
I think it was a 2,000 or 2,500.
The question was about 2,000.
I think that people who are frail, that 2,000 micrograms may, in certain circumstances, have a negative effect on them, yes.
Sorry, my question, doctor, was, did you say that 2,000 micrograms of fentanyl would be fatal to someone who is frail, someone who is critically ill, someone, who is opioid naive? Those are the kinds of people that might, with a dose of that degree, they might be at the most at risk for death.
Well, I think I said at risk. I said they were at risk for a fatal reaction. I didn't say that it would be necessarily 100% fatal.
Do you recall when being asked if 2,000 micrograms of fentanyl can cause death without supplemental oxygen, you answered, in certain circumstances, the answer to that would be probably.
This is in the Zane Floyd case?
Yes.
So the answer is yes.
Doctor, would you agree that a fentanyl overdose or midazolam overdose can cause pulmonary edema?
Well,
that... On the stool. Submitted.
I think so.
And you previously tested... Well, first, can you explain what a pulmonary edema is?
Pulmonary edema is fluid in the lungs, basically.
And you previously testified a pulmonary edema would likely manifest as difficulty with breathing, may first be accelerated breathing, maybe coughing, struggling to breathe. Is that correct?
This is, again, in the Zane Floyd case in execution. So I think in execution cases, this is my concern.
Does fentanyl cause pulmonary edemas in only people up for execution, or does it also have that risk for people in the hospital as well?
I'm not certain.
What would be the distinction of why the fentanyl would react differently based on whether a person is in the hospital or being executed?
Well, I think that in this case, was a combination. It was midazolam and fentanyl, not just fentanyl alone. So it's the midazolam that actually might be the problem, and the kind of dosages, again, are given are more on the order of 500 milligrams that are given in execution, not 10 milligrams like that are given in this case.
You further have stated that from a pulmonary edema, the worst case scenario, of course, a person could die of this. And no matter what I do, they would now drown and die of oxygen deprivation and so on. Yes or no?
In the context of the death penalty, yes, that's my concern.
a person could not die from a
Do you still
pulmonary.
want to maintain your objection?
It's been answered, so.
Well, I can strike it. Or are you fine?
Yeah. We have a standing objection, Judge.
So is it your testimony that a pulmonary edema might be fatal to someone on death row, but it could not kill someone in a hospital?
Okay, that's a different question what you asked before.
If I can re-ask my last question, you stated about pulmonary edema, worst case scenario, of course, a person could die of this. And no matter what I do, they would now drown and die of oxygen deprivation and so on. Is that your former testimony?
It's painful to hear you say you know a lot. I'm sorry that I keep saying that thing. I'll try not to say you know so much. But with respect to your question, can people die of pulmonary edema? The answer is yes, they can.
Doctor, you've also previously testified about the effects of ketamine, correct?
In the Zane Floyd case.
And
Objection on scope.
Scope of what?
Well,
Cross-examination.
your argument earlier, I think it's what he's getting to. The report. I point sidebar.
I'm sorry.
Yeah, let's crack it open. I'm a little warm. Are you guys? I assume since David asked, you were.
Doctor, when you testified about the synergistic effect of fentanyl and midazolam, you only talked about the pain, if they could affect each other in like increasing the effectiveness. Is that correct?
Are we talking about Zane Floyd, or are we talking about this case now?
Your testimony here.
So I'm sorry, ask me your question again.
On direct, when you were asked about the synergistic effect between fentanyl and midazolam,
Yes.
you only talked about whether they would make each other more effective.
Yes.
You would agree that there is also a synergistic effect between the two that increases the risk of respiratory depression, correct?
I would not agree to that.
Are you familiar with the Lexicomp guidelines on this issue?
Show me.
Am I allowed to show him?
I'd mark it and show it to him if it were me.
All right. It is marked as States Exhibit 26A already. Showing him States Exhibit 26A that was previously admitted. And I'm referring to this section right here.
Sorry, what is this from?
Lexicon.
I'm sorry, show me where again you're showing me. Let's see. I see, okay, so ask me your question.
Do you agree or disagree that concomitant use of narcotics and other CNS depressants may increase the risk of underventilation or apnea and may contribute to profound and prolonged drug effects?
I see that document says that.
Do you agree with that?
No, not really.
And Doctor, one of the last things I just want to ask you about, you are a member, one second. What were the ethics committees that you were a member of again?
I've been members of many hospital ethics committees, and I was a member of the ethics committee on the American Society of Anesthesiology and the Society of Critical Care Medicine.
I'm sorry, say that last one.
The Society of Critical Care Medicine.
And so you would be aware with the recommendations for end-of-life care in the intensive care unit from the ethics committee of the Society of Critical Care Medicine, is that correct?
If you something specific, you could just show me to remind me.
May I approach, Your Honor?
You may.
We'll mark it as States Exhibit 56.
Okay, so what exactly are you asking me about this?
Are you familiar with this?
I'm familiar with that document.
And this is one of the organizations you're a member of, correct?
But I'm no longer on the ethics committee.
If the ethics committee stated that, as a general rule, the doses of medication that a patient has been receiving hourly should be increased by 2- or 3-fold and administered acutely before withdrawing ventilation, would you agree or disagree with that statement?
Are you reading directly from that document?
Yes.
I mean, I say that I'm no longer on the ethics committee of the Society of Critical Care Medicine because I think that we have differing views on certain sorts of things around the end of life.
So you would disagree with their views on the end of life care?
I would. We have to go through the whole document, but in terms of dosage, I might disagree with that.
If they had set forth as guidelines that the typical starting dose for an adult of IV fentanyl administration...
Judge, this is already stated. He disagrees.
He said we'd have to go through piece by piece. I want to ask him about 2 pieces.
Finish up your question.
If the ethics committee set forth in their guidelines that for palliative extubation end-of-life care, the starting dose of fentanyl for an adult should be 50 to 100 micrograms of fentanyl. Would you agree or disagree with that?
I would say that other doses could be used. So I guess I would say I would disagree with that.
And if they recommended the typical starting dose in the same situation for midazolam would be 1 milligram, would you agree or disagree with that?
I would be surprised if it says that without making any mention about whether they were exposed or on either benzodiazepines or fentanyl. Is there a caveat in there that would inform that? Because if not, then of course that doesn't make any sense. It's poorly written if it doesn't have any of those other kind of provisions.
No further questions, Your Honor.
Redirect.
Sir, I want to start off with the statements that you made that you were asked about in the Floyd case.
Okay.
Where you make the statements of one of the possibilities, and in addition, one of the things that I might see in reference to respiratory depression, and with certain persons, it's a possibility. Are these all qualified answers?
They are qualified answers, yes.
And the reason is the reason for that, or are one of the reasons for that is because everyone is different?
Objection leading.
I mean, I think that the problem here...
Hold on, we got an objection.
Is everyone different?
Everyone is different.
Okay. Can you explain why you qualified your answers in that way?
I think that the struggle with the death penalty is that it is not a medical act, and so it impersonates one poorly. And so my struggle has been trying to answer these sorts of questions about taking medicine that are intended for the purposes of caring for people, treating people, reducing their pain, and turning them around and using them to poison and to kill. And so I collide with this constantly and trying to figure out how to answer these sorts of questions like we've been struggling with here. That Zane Floyd is a person who is facing execution. And so my work in lethal injection has always been this collision of this struggle of trying to make sense of these drugs, in my hand medicine, in the state's hand poison, and whether or not, where is the common ground? So all of these kinds of questions that I'm asked in the context of the death penalty, none of that has anything to do with when I use these drugs in the context of being a physician in a hospital.
Is the clinical picture the same for a person who's sitting in a cell waiting execution versus someone who is in an ICU about to be terminally extubated?
No, I mean, there's no comparison. No comparison.
And is that another reason why you gave those qualifications in your answers?
Well, that was I was trying to explain that a person facing execution has many things, a mental state, that is hard to fathom. And so a person who is, otherwise well, and so now they're going to be put to death. And so I'm trying to make sense of what the protocol that is being created by various states that do this and how it might affect a person as they die. And that's what I'm trying to understand, and it's a difficult thing to understand.
Were you asked any questions on cross-examination about any of these 14 patients?
No.
Were you asked about the effects of any of these doses on the 14 patients.
Sustained.
Now, do you recall being asked about a hypothetical that involved a person being brain dead and organ donation, and you referenced the records, that you didn't see anything in the records about someone being brain dead or organ?
Yes,
Okay.
I didn't read anything anywhere that said that anyone said that any of the patients were brain dead.
Now, I'd like to show you Joint Exhibit 2, page 22. Do you see that this is the name?
Outside the scope. I didn't ask any questions about the medical records.
Sustained.
I just prefaced this issue and this record based on the hypothetical that she was asking, that he referenced medical records.
Your Honor, can we take it off the screen?
I sustained it. You can ask another question, you can rephrase it, but in the format it was, I sustained.
Okay. Now, you were asked a hypothetical about someone being brain dead and possible organ donation. Do you recall that?
Yes.
And you, in fact, did not recall anyone as it relates to any one of these 14 patients being brain dead. I'm laying the foundation.
Finish your question.
You did not see any of these 14 patients, anything in the records about them being brain dead, correct?
I didn't see anything anywhere that said that any of the patients were brain dead.
I'll permit it.
Okay. Now, do you recall I'd like to publish this, Judge, based on the answers of the witness.
Did you show it to her?
Yes, okay. May I approach?
You may. Why, did you show it to her?
Yes, it is.
Okay. And you're objecting?
It's the same medical records, you just sustain the objection, Joe. It's beyond the scope.
I don't know what he has, so.
It's the medical record for Brian Hayes, Judge.
Okay, then no, you can't show that. It's outside the scope. You alluded to that earlier in your exam.
She asked a specific question about, in a hypothetical form. I want to just show the actual record of that hypothetical.
Okay, well, no.
Okay. Hypothetically, sir, if there was one of the 14 patients that they were waiting to see, if doctors were waiting to see whether someone was brain dead, and it was actually documented that they were breathing over the vent, would that...
Objection, Your Honor.
Finish your question.
Would that hypothetically mean that they are not brain dead?
I'm objecting as to what's actually documented.
Okay, overruled.
If a person is breathing spontaneously, they are not over the ventilator. They are not brain dead.
And hypothetically, if one of these patients' families wanted to be an organ donor, but the fact that they were not brain dead, would that still allow them to qualify to be an organ donor?
If a person has to be dead to be an organ donor, so a person that is breathing spontaneously is not dead and therefore cannot be an organ donor.
Okay. Can a personal injury lawyer declare someone brain dead?
Objection, Your Honor.
Are they also a doctor?
Outside the scope, sustained.
Okay. When you give talks to families, you can control what you say, correct?
I can.
And can you be as thorough
Objection
as...
to leading, Your Honor.
I didn't finish the question.
It's transitional, so go ahead.
Can you be as thorough as you feel you need to be?
I've been doing this for a long time, and so yes, I feel like I can communicate. Generally, it's not perfect. Sometimes you do everything, and you still can't make the connection.
Can you control whether a family understands you or hears you correctly?
Objection, Your Honor, speculation.
I'll permit it.
I can't, I try to ask questions back to people. Like I might say, tell me back in your words what you think I heard. So I'm trying to kind of, in the conversation, determine, what people are saying, or what they're hearing. But certainly on occasion, I felt that I've been very clear, and it turns out later on that people had it, heard it differently.
Now, you mentioned that in your hospital it takes 2 physicians to declare someone brain dead, correct?
Yes, I believe that's statutory, so I'm not sure.
Okay.
Yeah.
Okay, wait. Let's clean it up then because of his answer.
Yeah.
So let's.
That's a rule in my hospital.
That's the rule in your hospital?
Yes.
Okay. Do you know if that's a common rule?
I think it's common in other jurisdictions.
And were you shown during cross-examination any policy at Mount Carmel as to how many doctors?
Sustained.
Were you asked?
Objection.
Sustained.
Are you aware of the policy at Mount Carmel as to whether it requires?
Sustained.
When
I said sustained.
during end of life care talks with families, if there are nurses present and you make a misstatement.
Objection. Beyond scope.
I'm waiting for the rest of it.
This is part of
No, well.
If you give a talk and there's a nurse present and you make a false statement to the family, would you expect that nurse to speak up?
Objection.
Sustained.
In your training and experience, have nurses who were there at the bedside with you ever supplemented your talk?
Objection.
I'll permit that one.
Yes.
And do you find it their duty to supplement any of your talks?
Yes.
Now, you were asked about CCA and different code statuses. Are there different code statuses for different hospitals?
Yes.
Do they call it different things?
Yes.
Okay. Are you familiar with how Mount Carmel labels their different code statuses?
Objection. Beyond scope.
Can you read back the question?
I asked him if he was familiar with Mount Carmel.
Sustained.
Okay. In reviewing the records of Mount Carmel, of the 14 patients in this case, did that help you in determining what their exact code, the way they label their codes?
I think that in this case, what was clear is that in every circumstance, the way that it was documented.
Objection. Non-responsive.
I think he's responding.
I think he's responsible. Let's go.
Go ahead.
In every case, the way the conversation was documented was that a conversation took place, the family agreed, and the plan was, the pursuit of a palliative extubation. That was in every case. And that's what was documented. So in no case did anyone, in any of these cases that I read, that anyone said, let's keep going. I didn't read that.
Non-responsive.
I'll let him finish. Go ahead.
I didn't read that in any case.
Okay. Now, one last thing, going back to the Floyd case. You took a deposition in that case as well, correct?
I gave a deposition.
Yes. Did you give a prior sworn statement, not at the trial?
Yes.
Okay. And in there, do you recall actually making the distinction with palliative care versus the questions you were being asked?
I'd have to look again to see what I wrote.
May I approach the witness?
Yes. Ladies and gentlemen, while he's looking at that, we're going a little long. Anybody got anything that's pressing? I hope he's done soon.
I'm going to wrap up real quick.
Okay.
Yeah,
Hang in there then?
I see that.
Okay.
Yeah.
Does that refresh your recollection that you in fact made a distinction?
Finish the question.
Does that refresh your recollection that you in fact made a distinction between the execution scenario and palliative care?
Yes.
It's legal but I'll permit it.
Now, the articles you were showing, and what was that distinction, sir?
The distinction between palliative care and execution?
Yes.
Well, I mean, there's no comparison. So I think in one situation, a person is being put to death because of a legal decision. In the other case, a person is being allowed to die naturally as a consequence of their coexisting illness, and they're being supplied with medication to try to ease the pain of dying.
Do you recall being shown a series of articles by the prosecutor on cross-examination?
Well, I was shown several different articles.
Okay. And were those articles having to do with executions?
Which article? I'm sorry. I don't think...
Sure. I'm showing you State's Exhibit 68.
Well, this is, of course, called execution in Nevada to use powerful opioid fentanyl, so that's certainly death, execution.
Yeah, objection. I didn't show all of these articles to this court.
Well, I'm just showing them the one you showed. The article that was in CNN, that was in relation to execution, correct?
Objection, Your Honor. I don't believe this article was shown either.
Sustained.
Okay.
I think there were just 3 of them.
Is that the Gorsuch?
Let me re-ask another question,
please.
I'm about to wrap up. Okay, I'm showing you State's Exhibit 60, State's Exhibit 63. Oh, those 2. May I approach?
May.
Okay, yes.
Were they in reference to euthanasia?
They were in reference to euthanasia, yes.
What is euthanasia?
So euthanasia is the intentional killing of a person where the killing is done in as painless a way as possible. Ideally, completely painless is what it's intended to be.
And during cross-examination, did you testify that you are against euthanasia?
Yes.
Okay. Do you stand by that you are against a doctor intentionally killing someone?
I do.
Okay. And knowing that and having reviewed all the records in this case, you still chose to testify in this case pro bono?
I did.
I have no further questions.
Anything on the euthanasia?
Yes, Your Honor, but I need my exhibits back to find the one that I want.
Your rest? Okay. Ladies and gentlemen, go home. Have a great evening. 9 o'clock in the morning. We'll see you then. All rise. Doctor, you step down.
I'm sorry?
I told the doctor you to step down.
Okay.
Do you all want to have the next conversation in the back?
About what, Judge?
I don't think we need to.
Okay, I'm making a suggestion. Do you really want me to mention this now?
No,
Or do we
we'll
want
go
to
in the
talk
back.
about it in back?
We'll go in the back.
Okay.
Oh, you gave me a different one though too. That's what I was looking for. You gave me the Lexington one. That's what I was looking for.
I already took that.
Oh, okay. That's what I was looking for.
Yeah, I got it. All right, guys, so we got a 7 and a 7.